Bottle number 6, is voice clear? Sir, the person who is appearing through online by stating number, please put on your name. Otherwise, it will be disconnected automatically. Because no one was there to submit. He was there, but he didn't submit anything. If he stands directly,
Any mentionings through video? Any memos and mentioning?
Appeal number 1363 is against an order passed by the NA trial court wherein you have registered for the transcript copy of the FIR. The FIR filed in the Karnataka state was a subsequent FIR which was filed against the one which was filed in Tamil Nadu.
Whether this appeal is connected with other appeals?
No, Your Honor, it's a separate appeal. It's an order passed by the NA trial court.
Did you made an attempt to move this matter day before, couple of days back?
My senior had moved before the court order number 1. The reason being, earlier we moved the memo here. The registry was not.
Why did the matter was moved before court hall number 1?
Your Honor, I moved the memo 1 month back here. The registry was of the opinion that it would not come before this honorable court and should be heard by Justice Somashekar since he was the one who heard the bail matter. But that was not the case. We tried to explain it over there. But for the past 3 months, it was not being listed and we were left with no other option but to mention and only.
No, why do you invent some procedures which are unknown to High Court and put a wrong precedent?
Your Honor, the matter.
You are the advocates. You cannot mislead the court.
Your Honor, we have.
What is the urgency involved now?
Your Honor, the matter is posted for charge or plea before the NA trial court on 5th of this year, next month.
This Monday, take. Yes, please.
Your Lordship, pertaining to RFN 91 of 2017, which Your Lordship had passed a judgment and direction for the appellant to go before the civil court. But still the file is not been has to be done.
Disposal of this.
The judgment copy also along with me. But
When did you obtain the judgment copy?
June 6th,
June.
and we filed an IA to transmit the file also. We followed up with the branch, but the file is not received. Is what we.
ಹೀಗೆ ಮಾಡಿದ್ರೆ ಏನ್ರಿ ಮಾಡ್ಬೇಕು? ಇದನ್ನ ಹೈಕೋರ್ಟ್ ಅಂತ ಇರ್ಬೇಕಾ ಅಥವಾ ಸಂತೆಗಿಂತಲೂ ಕಡೆ ಮಾಡ್ತೀರಾ ನೀವು? ಯಾರಿಗಾದ್ರೂ ಒಬ್ಬರಿಗಾದ್ರೂ ಒಂದು ಗೌರವ ಅನ್ನೋದು ಬೇಕು. ನಮ್ಮ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಸರಿ ನಡಿಬೇಕು. ಎಲ್ಲರೂ ಕೇವಲ ಸಂಬಳ ಪ್ರಮೋಷನ್ ಇದ್ರೆ ಪ್ಯೂನಿಂದ ಹಿಡಿದು ನನ್ನವರೆಗೆ ಏನಾಗ್ತದೆ? ಲುಕ್ ಅಟ್ ಹಿಸ್ ಪ್ಲೇಟ್. ಹೀನಾಯ ನರ್ಕ ಅಂತ ಏನಾರು ಇದ್ರದು ಹೈಕೋರ್ಟ್ ಎಂಪ್ಲಾಯಿಗಳಿಗೆ ಮಾತ್ರ. ಯಾವ ಒಂದು ಪವಿತ್ರ ಸ್ಥಾನದಲ್ಲಿ ಇರ್ತಾರೋ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಅಂತ ಅವರೇ ಈ ರೀತಿ ಬೇಕಾಬಿಟ್ಟಿ ಬೇಜವಾಬ್ದಾರಿ ಕೆಲಸ ಮಾಡ್ತಾ ಹೋದ್ರೆ ಅವ್ರಿಗೆ ಯಾವತ್ತೂ ಎಕ್ಸ್ಕ್ಯೂಸ್ ಇಲ್ಲ. ನೀವೇನು ವೆರಿಫೈ ಮಾಡ್ತೀರಿ? ಅವ್ರು ಅಷ್ಟೆಲ್ಲ ಹೋಗಿ ಬಂದಿದ್ದಾರೆ. ಕೋರ್ಟಿಗೆ ಕೆಲಸ ಹೇಳಿದ್ರು ಒಬ್ಬನೇ ಒಬ್ಬ ರಿಜಿಸ್ಟ್ರಾರ್ಗೆ ನಾಚಿಕೆ ಅನ್ನೋದು ಆಗಲ್ಲ. ಅವ್ರವ್ರ ಸೆಕ್ಷನ್ಗಳನ್ನ ಅವ್ರ ನೆಟ್ಟಿಗೆ ಕೆಲಸ ಮಾಡಿಸಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? ಆಕ್ಷನ್ ತಗೊಳ್ಳಿ ಇಂಥವ್ರ ಮೇಲೆ ಅಂತ ಹೇಳಿದ್ರೆ ಆಕ್ಷನ್ ತಗೊಳ್ಳೋ ಧೈರ್ಯ ಒಬ್ಬರಿಗೂ ಇಲ್ಲ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ಆನರಬಲ್ ಚೀಫ್ ಜಸ್ಟಿಸ್. ಐ ಆಮ್ ಹೆಲ್ಪ್ಲೆಸ್, ಐ ಕಾಂಟ್ ಡು. ನಾನು ಮಾಡೋದೆಲ್ಲದೂ ಮಾಡಿ ಆಗಿದೆ. ಇಂತಿಂತ ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು ಕೂಡ ಅವ್ರ ಮೇಲೆ ಒಂದು ಆಕ್ಷನ್ ತಗೊಳ್ತಕ್ಕಂಥ ಧೈರ್ಯನೂ ನಮ್ಮಲ್ಲಿ ಯಾರಿಗೂ ಇಲ್ಲ. ನಮ್ ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್, ಜುಡಿಷಿಯಲ್ ಅಬ್ಸರ್ವೇಷನ್ಗೂ ಬೆಲೆ ಇಲ್ಲ. ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್ಗಳನ್ನ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಸೈಡ್ ಹೋಗಿ ಅದನ್ನ ಇಗ್ನೋರ್ ಅಂತ ಮಾಡಿಸ್ತಾರೆ. ಏನ್ ಮಾಡ್ಲಿಕ್ಕಾಗ್ತದೆ? ಈ ಹಿಂದಿನ ಮ್ಯಾಟರ್ನಲ್ಲೂ ನಾನು ಹೇಳಿದ್ದು ಅದೇ, ರಾಂಗ್ ಪ್ರೆಸಿಡೆಂಟ್ ವಾಸ್ ಪುಟ್ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, ಅದು ಇಂಥದೇ ಒಂದು ಇನ್ಸ್ಟೆನ್ಸ್. ಫೈಲೇ ಮಿಸ್ ಆಗಿಲ್ಲ ಇದು ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ಟ್ರಾನ್ಸ್ಮಿಟ್ ಅಂತ ನಾನು ಹೇಗೆ ಬರೀಲಿ? ನನ್ನ ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿಯೇ ಇದೆ, ರಿಜಿಸ್ಟರ್ ಟು ಟ್ರಾನ್ಸ್ಮಿಟ್ ದ ಫೈಲ್ ಫೋರ್ತ್ ವಿತ್ ಅಲಾಂಗ್ ವಿತ್ ಎ ಕಾಪಿ ಆಫ್ ದಿಸ್ ಜಜ್ಮೆಂಟ್. ಡೇಟು ಫಿಕ್ಸ್ ಮಾಡಿದ್ದೇನೆ ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ಲಿ ಇಂಥ ತಾರೀಕು ವಿತೌಟ್ ಎನಿ ಫರ್ದರ್ ಸಮನ್ಸ್ ಆರ್ ನೋಟಿಸ್ ಬೋತ್ ದ ಪಾರ್ಟಿ ಶುಡ್ ಅಪಿಯರ್. ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ? ಅವ್ರು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ಚೀಫ್ ಜಸ್ಟಿಸ್ ಹತ್ರ ಹೋಗಿ. ಇಂಥ ಮ್ಯಾಟರ್ಗಳು ಹೋಗ್ಬೇಕು ಸಂಬಂಧಪಟ್ಟವ್ರ ಹತ್ರ. ನಮ್ ಟಾಯ್ಲೆಟ್ ಅಲ್ಲಿ ನಲ್ಲಿ ಇಲ್ಲ, ನೀರು ಬರ್ತಿಲ್ಲ, 6,000 ಜನಗಳಿಗೆ ಊಟ ಹಾಕಿಸ್ತಿದೀವಿ, ಅದಲ್ಲ ಇದು. These are the matter which should come to the notice of the honorable chief. ಹೋಗಿ ಮಾಡಿ. Yes.
Serial number 7 in list number 1. But I have one more parted matter in court or 5.
ಮೊನ್ನೆ ಬಂದಿತ್ತಲ್ರಿ ಇದು?
ಮೊನ್ನೆ ಬಂದಿತ್ತು. ವಿಕ್ಟರ್ ಮನೋಹರ್ ತಿರ್ಸಿದ್ದೀನಿ. ನನಗೆ ಅಲ್ಲಿ ಪಾರ್ಟೆಡ್ ನಿನ್ನೆಯಿಂದ ಕಂಟಿನ್ಯೂ ಆಗ್ತಾ ಇದೆ ಕೋರ್ಟ್ ಆರ್ 5 ಅಲ್ಲಿ.
ಇದು ರಿಪೀಟೆಡ್ಲಿ ಬರ್ತಾ ಇದೆ, ನಾಟ್ ರೀಸೆಂಟ್ ಆಗಿದೆ 2 ಸರ್ತಿಯೋ ಏನೋ. ನೀವು ಒನ್ ಡೇ ನೀವ್ ಇರ್ಲಿಲ್ಲ, ಆಮೇಲೆ ಬಂದ್ರಿ.
ಹೌದು, ಈಗ ವಿಕ್ಟರ್ ಅವರನ್ನು ಮಾತಾಡ್ಸಿದ್ರೆ ಅವ್ರು ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ.
ಆ ಪಾರ್ಟಿ ಹೆದರ್ಸ್ಬಾರ್ದು ನೀವು.
ಇಲ್ಲ ಹೆದರ್ಸಿಲ್ಲ, ಅವರೇ ಮೊನ್ನೆ ರೆಡಿ ಇದ್ರು. ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಕೇಳಿದ್ರೆ ನಾನು ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಅವರೇ ಹೇಳಿ.
ನೀವು ಸ್ವಲ್ಪ ಹುಷಾರಿರಿ.
ಜೋರಾಗಿ ಬಂದಿದ್ದಾರೆ, ಸಿನಾಫೀಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
Learned counsel for the accused in both the appeals and the learned CGP for the appellant in learned additional SPP for appellant in criminal appeal 1836 of 2017 are physically present. Learned counsel for the accused stating that he is engaged in another part-heard matter before another court for the whole day today, prays for a day's accommodation in this matter. In view of the same, the matter could not be proceeded today. ನಾಳೆಗೆ ಎಷ್ಟಿದೆ ಪಾಠ?
ನಾಳೆಗೆ ಒಂದಿದೆ ಪಾಠ, ಎರಡು ಪಾಠ.
List this matter on 24/11 on the top of the list. Yes. Yes, call the case.
Against the province subsection second time, serial number 1, SPP.
ಇಮಿಡಿಯೇಟ್ ಕಳಿಸ್ತೀವಿ. ಈ ಪಾರ್ಟಿಯ ಬೇಜವಾಬ್ದಾರಿ ನಮ್ಮಲ್ಲಿ ಇರ್ತದೆ. ಹಾಗೆ ಹೇಳ್ತಾರೆ ವಕೀಲರುಗಳು. Yes, please.
Sir, wait for a week's time to comply the
At the request of the 11th CGP, as finally a week's time is granted. 10 days more. As finally 10 days time is granted to comply of the subsection.
Admission matter, serial number 2, SPP. Umesh Mulimane for respondent 1, 2 and 3, respondent 3rd.
So I have to go support in the matter.
17 and 21. Sorry. Fact with data that allowed the accused, use the victim girl who was aged 16 years, my lord.
Admit paper book 16. Yes.
Further arguments matter, serial number 3,
Archana KM, amicus curiae for appellant, Vinayak VS for respondent, amicus curiae, connected matter.
For the balance state.
Main evidence is of the mother and daughter.
Need the evidence of the doctor.
Mother and daughter, all the alleged 3 eyewitnesses have turned hostile, not supported the case. Medical evidence is there regarding the injury. 2 doctors, one who initially treated, a PG student has come and deposed the evidence. The another is Kollegala doctor, Janani Hospital. Lacerated wounds, 4 injuries on the backside of the neck. In the cross-examination, it has been observed that it has been stated by the doctor that in case of a forcible assault with the nails on the backside of the neck, there is all the possibility of a fracture of the vertebral column. In the instant case, no such fracture. This is the summoned substance. So no need to read the evidence of any of the witnesses. Go to the
My lords
point.
have read the evidence. My lords have read the evidence of the witness, not directly to the judicial authority.
You are for the victim. Good. Yes, please.
By one subject. Whenever the fighter has been.
Yes. Yes, please.
The first point was that the accused attempted to cause death of the victim with an intention to kill the victim. Knowing fully well that such bodily injury caused by him is sufficient to cause the death of the victim. Thereby, the offense under section 307 is committed by the accused.
Yes.
My submission to that point is that, my lord, if you consider the evidence of PW1 and the evidence of doctor PW11 and 18, read with the wound certificate issued by the doctor and the case sheets of the doctor at the Janani Hospital, my lord, the opinion of the doctor, my lord, clearly shows that, my lord, the injury is caused to the victim. So it's proved that, my lord, the injury has been caused to the victim. It is also not disputed by the accused, my lord, that there is no injury caused to the victim. If that is accepted, my lord, the next question would be whether the accused had any intention to kill the victim. For that, my lord, my submission would be that, my lord, if we consider the evidence of PW1, my lord, in her evidence, my lord, she has stated, my lord, over the phone also, he has threatened that if she did not inform her parents to enter into a compromise in a case which was filed by them against the employer of the accused, my lord, he would kill her. That is in page number 56.
So what is the evidence on record to show that there is a litigation between the other two with the mother of
There
this
is no material has been placed by the prosecution that there was a litigation, my lord.
That is a
But
motive
that-
according
that-
to your case. That is a motive.
But that itself is not shows that, my lord, there was a intention. By the circumstances of the other witnesses and the intention, the weapon used by the accused and the body parts
That is
selected
different.
by the accused.
Yeah, that is a different part. You say that there was a motive for this accused to commit the murder of this lady, that girl.
There is no documentary evidence, my lord, but the evidence of PW2 and the
Suggestion was that there is no such litigation pending between the
Please.
PW2 and the other two names persons whose name is mentioned in the suggestion.
Lord, my respectful submission is that, my lord, to constitute the offence under section 307, my lord. The intention to kill is more important, my lord. Whether the prosecution has put the motive is immaterial in this particular case, my lord.
No, here you made out a case that there was a motive.
Yes, my lord.
Some persons just try to shoot in the public and causes the injury or death, then that is a different issue. Here the intention was that unless this lady withdraw that case, he will kill her. Motive is the pendency of a case.
Yes, my lord.
He did not withdraw that matter. Therefore, he was intended to murder her.
Yes, my lord. But there is no documentary evidence to show that there was a dispute between the employer of the accused and the father and mother of the victim, my lord.
Is there any
Right.
explanation given by the investigating officer for not securing the document?
No, my lord. That was not good.
Totally that was ignored by you.
Yes, my lord. But my submission is, my lord, constitute the offence under section 307, my lord. The evidence.
To constitute any offence, unless it is something different, intention is a must.
Yes, my lord. My submission is that, my lord, the intention of the accused to kill the victim could be made out by the bodily injury caused to the victim itself, my lord. The selection of the body part of the victim and the weapon used by the accused itself shows that, my lord, he has every intention to kill her, my lord.
Yes.
But my respectful submission is that, my lord, it is a well settled principle of law, my lord, by various judgments of the Supreme Court. It said that, my lord, to prove the offence under section 307, my lord, the intention of the accused can be ascertained from the actual injury caused to the victim and the nature of the weapon used on the severity of the injury. That has to be considered to infer that the offence has been committed with an intention to kill the victim. In this case, my lord, the accused has used the weapon axe, my lord. It is a dangerous weapon, my lord. If any assault is done by the axe, my lord, it result in the death of any person, my lord. And the accused has caused the injury on the vital part of the body, that is the neck and chest of the victim, my lord. This itself proves that, my lord, the accused had the intention to kill the victim, my lord. And even the trial court, my lord, has come to the conclusion that, my lord, the evidence of PW1 and 2 are cogent and consistent with respect of the case of the prosecution. And that is also not disputed by the accused, my lord, where he has accepted the order of conviction.
Because in this case, one of the defense of the accused is that he was not of sound mind.
There is no produced by the defense in that regard, my lord. Where suggestion to the witness is not sufficient. Come to a conclusion that, my lord, he was not of sound mind. And it was also the But it was also the case of the defense that as they did not agree for the marriage of the victim to the accused, my lord, the false case has been against the accused, my lord. But there is no proof produced by the accused. They have not at all explained that in the P13 statement also, my lord. And they have not adduced any evidence before this honorable court to prove that even he was of unsound mind, or the other defense that as there was a denial and as the parents of the victim were not interested in giving the victim in marriage to the accused, they have filed the false case. Merely because, my lord, if they are not interested in the marriage, this is not the way, my lord, they could have refused the marriage itself, my lord. There is no necessity for the parents of the victim to file a false case at all. And when the injuries, injury and the assault by the victim has been proved, my lord, the intention is also proved, my lord, that is with respect to submission.
Anything else?
Lord, with respect of the charge against the accused for the offences under section 354, my lord, the trial court, my lord, has come to the conclusion that, my lord, there is no material at all produced by the prosecution to prove the offence under section 354, my lord. The relevant discussion is at page number 11 of the judgment. Page number 10 of the judgment. The para number 14. May I read the relevant question?
Yes.
As stated, Supra PW2, Umaira Banu is mother of the complainant. She states in her evidence that on 27/12/2013, at about 10 a.m., she had been to the shop, and at that time, accused was coming holding axe from his house, and in the meantime, her daughter came out from the lavatory, and when her daughter PW1 was putting bolt of the door of the lavatory, the accused assaulted PW1 with axe on her right shoulder and on the left side of neck. And on seeing the same, she raised cry, and on hearing her cry, CW325, that is PW325, came to the spot. So far as the giving message and talking over the phone by PW1, the accused are concerned, she states that subsequently she came to know through PW1 that the accused had given a message stating, "I love you," and thereafter accused was talking with PW1 over the phone. And they were loving each other, and she was not knowing the same. And subsequently she came to know the same after this incident. Except these evidence, there is no other evidence to show that the accused had used criminal force or dragged PW1 by holding his hand with an intention to outrage her modesty, or he was following PW1, or he was in touch with PW1 with sexual intention. Therefore, prosecution has failed to establish that the accused has outraged the modesty of PW1 and sexually harassed her. Accordingly, point number 1 and 2 are held in the negative. This is the discussion with respect of accused offense under section 354 of IPC. But my submission for this offense is that, my lords, consider the mahazar of the spot, my lord. When we made out, my lord, there was a 10-feet road next to the lavatory of the victim's house. So it shows that, my lord, the scene of offense is at public view, my lord.
Yes.
My lords also may consider the time of the offense committed by the accused, my lord.
Morning.
It was in the morning at around 10:30 a.m. where people will be moving around in the village, my lord. And my submission is that, my lord, by assaulting her in public place, my lord, he intended to insult the victim, my lord, who was a woman.
Other ingredients of section 354 attract.
My submission is that, my lord, modesty of a woman need not be always physical, my lord. If it hurts the feeling of a woman, my lord, by the act of the accused, my lord, it has hurt the feeling of the woman, the victim was a woman. The accused has committed this act to show that, my lord, he can overpower her. She has to listen to whatever the accused says. If she does not do that, my lord, he will go to the level that he will insult her in public manner.
Yes.
My lords, consider the act of the accused in this perspective, my lord. The offence under section 3454 is also attracted against the accused, my lord.
This prior to amendment.
ಹಾಗಾದ್ರೆ ಗಂಡಂದ್ರಗಳಿಗೆ ಕಷ್ಟ. ಹೆಂಡತಿಯ ಫೀಲಿಂಗ್ ಒಂಚೂರು ಹರ್ಟ್ ಆಗಿ ಬಿಟ್ರೆ she can complain, you have outraged my modesty ಅಂತ.
Law should be developed.
Already there are several provisions which are sufficient.
Any other point?
With respect to the offences under section 4, so I have one submission to it. My lord, the age of the victim is not disputed, my lord, and the certificate of the victim was produced. The exhibit P14 and the 15. And, it shows that, my lord, the victim was minor at the time. Then. And she, my lord, in her reference, my lord, she says that, my lord, the page number 57. In the beginning, also, my lord, she said that, my lord, he had sent the message, I love you. And also, my lord, she says that ಬೆಂಗಳೂರಿನಲ್ಲಿದ್ದಾಗ ಪದೇ ಪದೇ ಫೋನ್ ಮಾಡಿ ನಿನ್ನನ್ನು ಪ್ರೀತಿಸುತ್ತೇನೆಂದು ಚುಡಾಯಿಸುತ್ತಿದ್ದ ಹಾಗೂ ತೊಂದರೆ ಕೊಡುತ್ತಿದ್ದ. And this evidence of the victim, my lord, has not been disputed by the accused. Even in his cross-examination to the victim, my lord, no question was put to her in this regard. And in view of the admission, my lord, clearly proves that, my lord, the offence under section 11 was 4, read with section 12 of the POCSO Act. And he was also telling her that he loves her and he was intending to marry her, my lord. It itself shows that he had done this with a sexual intent.
Yes.
Permit, I would like to rely on one judgment of the Supreme Court, my lord. With respect to the offences under section 327, my lord. 2021 ICC online 1046. Sadakat Kotwar and another person, State of Jharkhand, my lord. In that, my lord, in paragraph number 7, we read out the paragraph.
Yes, please.
It is not the case with the accused that the offence occurred out of a sudden quarrel. It also does not appear that the blow was struck in the heat of the moment. On the contrary, considering the dispositions of PW7 and 8, the accused person pushed and took the husband of PW7 out of the house, and thereafter the accused caused the injuries. PW7 and PW8 and stabbed driver. This deadly weapon have been used and the injuries are found to be grievous in nature. As the deadly weapon has been used, causing the injury near the chest and stomach, which can be said to be on vital part of the body. The appellants have been rightly convicted for the offence under section 307, read with section 34 of the Act. As observed and held by this court, in Katana decisions, nobody can enter into the mind of the accused, and his intention has to be ascertained from the weapon used, part of the body chosen for assault, and the nature of the injury caused. Considering the case of hand on the aforesaid principles, when the deadly weapon dagger had been used, there was a stab injury on the stomach and near the chest, which can be said to be on the vital part of the body, and the nature of the injuries caused is rightly held that the appellants have committed the offence under section 307(5).
Yes, good. Mark the relevant portion. That's all. Yes.
For the complaint, yes. But there is right. The facts of the complaint, according to the complaint reports, as everything remains the same up until the assault violence. According to the complainant, the eyewitness is the mother. The rest PW3 have come. They have witnessed only the accused holding the weapon violence.
Even according to complainant, mother is not an eyewitness. Mother says that she is an eyewitness. Read the complaint reader evidence.
Complainant.
Yes.
ದಿನಾಂಕ 27/12/2013 ಬೆಳಿಗ್ಗೆ 10ರಿಂದ 10:00 ಸಮಯದಲ್ಲಿ ನಾನು ಹೊರಗೆ ಬರುತ್ತಿರುವಾಗ ಕೊಡಲಿಯಿಂದ ನನ್ನ ಕತ್ತಿನ ಹಿಂಭಾಗಕ್ಕೆ 3 ಬಾರಿ ಹೊಡೆದ ಹಾಗೂ ಎದೆಗೆ 1 ಬಾರಿ ಹೊಡೆದು ನಾನು ಬಿದ್ದು ಹೋದೆ. ಆಗ ನನ್ನ ತಾಯಿ ತಾಯಿ ಚಾಸ ಒಂದು ಮೂಲದಿಂದ ಇದು ಬಂದರು ಅವರ ಅದನ್ನು ನೋಡಿ ಆರೋಪಿ ಹೊಡೆದು ಬಿಸಾಕಿ ಓಡಿ ಹೋದ.
That means ಅವ್ರು ಹೊಡೆದಾದ್ಮೇಲೆ ಬಿದ್ರ ಮೇಲೆ ತಾಯಿ ಬಂದು. That is the version of the complainant.
Second paragraph. ನನಗೆ ಹೊಡೆದ 6 ಗಂಟೆಯ ನಂತರ ನನಗೆ ಪ್ರಜ್ಞೆ ಬಂತು. 6 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ಏನೇನಾಯಿತು ನಡೆಯಿತು ಅಂತ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸರಿ 6 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ವೈದ್ಯರ ಮುಂದೆ ಯಾರು ಹೇಳಿಕೆ ಕೊಟ್ಟರು ಗೊತ್ತಿಲ್ಲ. ನನ್ನ ಜೊತೆ ನನ್ನ ತಂದೆ ತಾಯಿ ಹೋಗುತ್ತಿದ್ದರು. ಈ ಘಟನೆಯಿಂದ ಮೊದಲು ಆರೋಪಿಯ ಜೊತೆ ಯಾವುದೇ ಗಲಾಟೆ ಮಾಡಿರಲಿಲ್ಲ. ನಮ್ಮ ಮನೆಯ ಸುತ್ತಲೂ ಬೇರೆ ವಾಸದ ಮನೆಗಳು ಇದೆ. ನನಗೆ ಏಟು ಆದಾಗ ನನ್ನ ಅಮ್ಮ ಮಾತ್ರ ಇತ್ತು, ಬೇರೆ ಯಾರು. This corroborates with PW2 who says, here she screams. Her mother comes, and that's where after the mother comes, the mother screams, and the other two come in. That is the evidence of PW2.
Second paragraph.
Second paragraph, PW2 man. Third paragraph. ಅಲ್ಲ, ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಮಧ್ಯದಲ್ಲಿ ಶೌಚಾಲಯದಿಂದ ಬಾಗಿಲನ್ನು ಚಿಲಕ ಹಾಕಿ ಬರುತ್ತಿದ್ದಾಗ ಆರೋಪಿ ಕೊಡಲಿಯಿಂದ ಕುತ್ತಿಗೆಯ ಬಲಭುಜದ ಕಡೆಗೆ ಹಾಗೂ ಇನ್ನೊಂದು ಏಟನ್ನು ಎಡಭಾಗಕ್ಕೆ ನಾನು ಅದನ್ನು ನೋಡಿ ಕಿರಿಚಿದೆ. ನನ್ನ ಕಿರಿಚಿದ್ದನ್ನು ನೋಡಿ ಚಾಸ ಮುಂದಿನಿಂದ ಓಡಿ ಬಂದರು ಹಾಗೂ ಕಸ ಬಂದರುವುದನ್ನು ಎತ್ತಿಕೊಂಡರು. Lordship of Carries the eyewitness here is the mother who has seen the accused hit the.
Two sentences prior to that, which you have read.
ಆರೋಪಿಗೆ ಯಾಕೆ ನಮ್ಮ ಮನೆಯ
ಶೌಚಾಲಯ ಸಮಯದಲ್ಲಿ ಕೊಡಲಿಯಿಂದ ಅಂಗಡಿಯಿಂದ ಸಾಮಾನು ಹಿಡಿದುಕೊಂಡು ಬರುವಾಗ ಆರೋಪಿ ಕೈಯಲ್ಲಿ ಕೊಡಲಿ ಹಿಡಿದುಕೊಂಡು ಅವರ ಮನೆಯಿಂದ ನಮ್ಮ ಮನೆಯ ಕಡೆಗೆ ಬಂದ. ಆಗ ನಾನು ಆರೋಪಿ ಯಾಕೆ ನಮ್ಮ ಮನೆಯ ಕಡೆ ಹೋಗುತ್ತಿದ್ದಾನೆ ಎಂದು ಆಶ್ಚರ್ಯದಿಂದ ನೋಡಿದೆ. ಶೌಚಾಲಯದಿಂದ ನನ್ನ ಮಗಳು ಹೊರಗೆ ಬಂದರು. ಶೌಚಾಲಯದ ಬಾಗಿಲನ್ನು ತಿಲಕ ಹಾಕಿ ಬರುತ್ತಿದ್ದಾಗ ಆರೋಪಿ ಕೊಡಲಿಯಿಂದ ಕುತ್ತಿಗೆಯ ಬಲ ಭುಜದ ಕಡೆಗೆ ಹಾಗೂ ಇನ್ನೊಂದು ಏಟನ್ನು
how the case of the accused is my how the case of the victim is my submission. That is a slight change in the fact. My opening statements would be that every criminal offense is composed of essential components or ingredients, predominantly the mens rea and actus. But here 307 there are 4 stages. The first stage comes the mental stage where the intention of committing the offense is formed in the mind. The second stage comes in the preparation, in which the offense plans the commission of the offense in the next means. The third stage is another attempt which is made under which the plan is executed. And fourth stage will be the accomplishment of the crime. Murder is one of the gravest offense fellows. And nothing but a paid act in the murder. That being the case, my lord, I would like to point out how the trial court has erred in convicting the accused in 307. If your lordship kindly see the trial court order, nowhere has the trial judge stated the reason why it does not come under 307, but it comes in the pre-pending.
No, what error he has committed, we will see later. But to satisfy us that such ingredients of section 307 are fulfilled. If you satisfy that 307 is attracted, then obviously we have to hold that trial court has committed error.
The evidence PW1, PW2, the mother, the eyewitness, 11, the doctor, and 18 with the medical certificate. And 17, the investigation officer who has been part of all of the exhibits. That's here what I would like to point out here. The trial judge had convicted the accused in the 321 state injury nature, but has not intention. Clearly the intention. No intention. The word assault the girl. They were very much in love. Initially, he started, then the love blossomed, and everything was fine. There was one person called Khalim or Zamir, where there was a court case going, and he interferes in that and tells the girl to negotiate, ask her parents to negotiate. That was the intention, but she clearly told that she had received a threat by the accused. Yes. But no doubt you launched. In the evidence, she is told, ಏನು ಗಲಾಟೆ ಇರಲಿಲ್ಲ ನಮ್ಮಿಬ್ರು ಮಧ್ಯೆ ಅಂತ ಒಂದ್ ಕಡೆ ಹೇಳಿದ್ರು. ಗಲಾಟೆ ಇದೆ. Yes, he is clearly threatened what is being mentioned.
Yes.
Right? Only in simple nature, but in the past,
What it has helped.
such action might cause death, then the provisions of section 307 of Indian Penal Code would be applicable. There is no requirement for injury to be on a vital part of the body. Merely causing hurt is sufficient to affect injury. So, my lord, three cases, the vital part of accident, weapon, with a very deadly weapon, that is the intention, not, my lord, the third part I read of the third state had this, well, the essential ingredients of first, the intention, the knowledge. Second is the nature of that. Third is the execution of that. The last one, the intention was clearly that she did not listen in telling her parents to get the matter settled. That is the clear intention. But that the parents were not ready to get her married. That is a clear intention. It's not denied by the defense. The defense is not at all laid out any evidence. Second, nature of if it went as planned by the offender, it did not be hindered due to any interruption. Here the interruption was the girl's scream, and then the mother she screamed. Actually not scream, he would have killed it. That is the nature of the act. The part. He had already planned. He had a maximum. Comes from the previous step where the intention is there. Then there was preparation. He was not standing simply. He did not take some act then and there. He had it with us. Then had if it had planned, that one has planned, then he would have given it, but the screaming of the girl. So, this becomes the deciding factor of the intention. The question of the nature of the act and the definition itself shows. It's nothing but a plain element of murder, where the intention is to kill her. Arithmetic is followed by all the ingredients. And the act is done, it's not, when they take the different thing, it's not a sound mind. That's firstly, even if you say that Ashuddha Christian maybe Yellow done. If he was not a sound mind, he could not have answered any of the secondly, he was not, there was no medical certificate given here in that regard, that he cannot be, he's not a fit candidate to give evidence. Another certificate. Okay, in that view of the matter, then it is that not know that was only to avoid his those 7 being convicted as his those 7. That's my submission. Because the intention was very clear. He had another thing, if he was not of sound mind, message that the very fact that he could say I love you to someone does not, it shows that he was not a sound mind. But testimony of the victim herself clearly says that just the previous day had been telling her that he would kill her, and on the previous day he told her when the parents had gone It is not, but that is the clear intention. To be innocent. But statement is what, it is that the intention only to cause hurt, but not the intention of causing harm. ಇಲ್ಲಿ ಕ್ಲಿಯರ್ ದಯವಿಟ್ಟು ಹೇಳಿ ನಿನ್ನ ಹೊಡಿತೀನಿ ಅಂದು ಇದು ಮಾಡಿದ್ದಕ್ಕೆ ನಾನು 317 ಹಾಕ್ತೇನೆ ತಪ್ಪ. He's clearly told he's going to get, he's going to kill. And yes, continue. Because 324 is a simple hurt is called and voluntary because none of these ingredients come there. In fact, my lords, the Supreme Court has also held. May I?
What it says.
As I mentioned earlier, even if it is, there is merely causing hurt, it's sufficient if the intention.
That's the first judgment which have relied upon. The pass it on. Mark the relevant portion.
The latest. Merely because injury sustained by the complainant were very simple in nature, that would not absolve the accused to be convicted from what is important is an intention there was an intention. He is asserting the proved by cogent evidence that the act is had right to assault, and that too thus held. The complainant received injuries on the right shoulder while avoiding but the trial judgment also.
Yes.
The mother has also gone on to give a police complaint. Also, corroborated by this degree where the mother has gone and given the police complaint also. In her evidence, she states, madam, ಈ ಕೋರ್ಟಿನ ಈ ಕೇಸ್ನ ಗಮನ ಬಂದ ನಂತರ ಆರೋಪಿ page 61 of the paper. ಈ ಕೇಸನ್ನು ರಾಜಿ ಮಾಡಿಕೋ ಇಲ್ಲದಿದ್ದಲ್ಲಿ ಕೊಂದು ಬಿಡುವುದಾಗಿ ಬೆದರಿಕೆ ಹಾಕಿದ್ದ ಆಗ ನಾನು ದೂರು ಕೊಟ್ಟಿದ್ದೇನೆ. Which is produced the endorsement in that way.
Endorsement is at exhibit. Yes.
This is for PW. One number that is the respective period. 11 of folks on the first. PW. Where my lords has given the certificate and it is not being challenged anywhere. Nowhere has been questioned about her age. And in her evidence, she clearly tells my lords, Bengaluru Viddaga Pade Pade. So if I may read out, Photo Act, my lords, under this comes from me, I read out my lords. Section 11(4). Repeatedly or constantly follows or watches or contacts a child either directly or through electronic, digital or any other means or so. Here a dozen last, but initially this was also one of the ingredients. Charges were framed by the magistrate. Becoming info 1, 6 and 7, my lords. And the spot only, my lords, it was recovered, the body was recovered, it was identified and supported by PW 7. My lords, the victim identified that and PW 17, the investigation officer also has signed, my lords. In fact, it was PW 4, my lords, who has taken the investigation officer to that place and got that mark. In fact, PW 4 and 7 exhibit only 4 only they admit they have done, they might have done hostile, but our particular crime scene and photo responses they admitted. And MO 2 to 5 also required an exhibit P8. And my lords, the FSL report says there was blood group of the victim on the group.
Equally.
Exhibit 17, where PW 16 and PW 17 supported the
Refresh.
P13 and blood group
P13.
P13 and blood group certificates corroborates with status.
Yes.
The trial judge members had gone. I think of just saying that he's a first time offender and that he's young. And has fined him for the only job what my lord is. The trial court has erred, my lords, in not considering the intention. Whereas all the, my lords, the intention is clearly established. And there is nothing to disbelieve this. There is no defense at all on that regard. On intention, really love, bhakti lights, and admit fact they have known each other. Everything is. It's not been. And when the nature of the act is such that had it not been stopped, she would have been killed. So when that being the case, and then there was preparation for this very event, all of these satisfying my lord section P07 should be goes on the accused my lords. My lord, the trial judge also at internal page 17 my lords. One day kade 307 Marala entire judgment the entire trial judge has gone after the injuries. Now, this is not intention anywhere. Lastly, it is not punishable under 3026 or 307. As the act of the accused falls under the purview of 324, causing simple injury to deadly weapon. Adbitre intention illa.
ಬರೀ ನೀವೆಲ್ಲರೂ ಟ್ರಯಲ್ ಜಡ್ಜ್ಗಳನ್ನ ಬೈಯದ್ರಲ್ಲೇ ಇರ್ತಿರೋ ಹೊರತು ನೀವ್ಯಾಕೆ ಜಡ್ಜ್ಗಳು ಆಗಲ್ಲ? ಎಲ್ಲ ಯಂಗ್ಸ್ಟರ್ಸ್ ಕರ್ದು ಕೇಳ್ತೀವಿ ಜಡ್ಜ್ಗಳು ಆಗ್ರಿ ಅಂತ. ಅಪ್ಲಿಕೇಶನ್ ಬರೋದು ನೋಡಿದ್ರೆ ಬಹಳ ಕಡಿಮೆ. ವೈವಾಕ್ ಎಲಿಜಿಬಿಲಿಟಿ ನೋಡಿದ್ರೆ ಇಲ್ವೇ ಇಲ್ಲ.
Page number 22 ಅಥವಾ ರನ್ನಿಂಗ್ ಪೇಜ್ ನಂಬರ್ 32 ದಲ್ಲಿ ಇದೆ. ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ. Page number 22. But PW11 clearly admits in the middle of the first paragraph. Middle of the first paragraph. Page number 22. Internal page 22. Middle of the first paragraph.
According to
As per version of PW11 that
there was cervical bone and veins and the injuries that exist in each other. PW11 clearly admits that if an assault was made forcibly with an axe on the neck, there are chances of causing fracture of the cervical. But admittedly, no such fracture has occurred. Therefore, it is clear that the accused had not used force while giving blows and he had no intention to commit. Again, it boils up to the injury force, intention, it's not been explained. It's one of the and hence it appears that some vacillations have been caused. Considering all these aspects, the court is of the view that the said injuries caused to PW1 are simple in nature. Considering these aspects, the court has held that questions under 326 and 307 are not obstructed and he is committed. So this the answer of the Supreme Court, my lords, which has laid out that the injuries don't matter. We had the intention.
307 doesn't say anywhere that there should be injury. 307 nowhere it says that there should be an injury.
But there is an overdraft following the intention.
Intention is a must.
There's a submission is be convicted under 307 and section 11(4) of POCSO laws concerning the age of the girl who was subjected to a previous assault.
Yes, accused.
Charges came by the building. 11, 4, and 12, the Arabic section 12 of the books. The 324, 354, 326, and section 307. My humble submission to this honorable trial court has convicted the accused for the offense in section 324 of. Now, as far as the first charge 326 is concerned, 326 says, kindly I would like to draw your lordship kind attention. 326.
Voluntarily causing grievous hurt by dangerous weapon or by dangerous means.
Yes.
Yes.
Grievous by means of any instrument for shooting, stabbing, or cutting, or any instrument which used as a weapon of offense is likely to cause death, or by means of light, or any hated substance, or by means of so and so, which it is deleterious to the human body to inhale, or to swallow, or to receive into the blood, or by means of any man shall be punished so and so. My humble submission to this honorable report. Exception is 335 is given. 335 is given.
Grave and sudden provocation.
Provocation. My humble submission to this honorable court. There is no material adduced by the prosecution that the injury caused to the appellant is grievous in nature. To that effect, medical evidence adduced by the prosecution, the doctors have clearly stated that the injuries are simple in nature.
Doctor, ಹೇಳಿದ ನೋಡ್ರಿ ಫಸ್ಟ್ ಟ್ರೀಟ್ ಮಾಡಿದವರು ಗ್ರೀವಿಯಸ್ ಇಂಜುರಿ ಅಂತ.
Yes, sir. Wound certificate.
Dr. Kali.
Yes, sir. PW
18.
Complainant or state have no grievance for not convicting the accused under section 326 subject. See, they only say that 307 was not attracted or he was not punished for section 307.
I will constrain to that. But as far as the evidence of PW 11 is concerned, PW 11, kindly. PW 11, Dr. Samson. ಕುತ್ತಿಗೆ ಹಿಂಭಾಗದಲ್ಲಿ ಮಿಡ್ಲ್ ಪೋರ್ಷನ್ಸ್ ಅವಳ ನಮ್ಮ ಆಸ್ಪತ್ರೆಗೆ ಬಂದಾಗ ಅವಳ ಎದೆ ಬಡಿತ ರಕ್ತದ ಒತ್ತಡ ಸಾಮಾನ್ಯವಾಗಿತ್ತು. ಐ ಹೋಪ್ ಸಾಮಾನ್ಯವಾಗಿತ್ತು. ಆಕೆಯ ಕುತ್ತಿಗೆ ಹಿಂಭಾಗದಲ್ಲಿ 4 ಕಡೆ ಹರಿದ ಗಾಯಗಳು ಆಗಿದ್ದವು. ಎದೆಯ ಭಾಗದಲ್ಲಿ ಸಹ ಒಂದು ಹರಿದ ಗಾಯ ಆಗಿತ್ತು. ಅವಳು ನಮ್ಮ ಆಸ್ಪತ್ರೆಗೆ 27/12/13 ಒಳರೋಗಿಯಾಗಿ ದಾಖಲೆಯಾಗಿ 28/12/13 ಮಧ್ಯಾಹ್ನ 3 ಗಂಟೆಗೆ ಬಿಡುಗಡೆ ಆಗಿದ್ದಾಳೆ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಥರ್ಡ್ ಲೈನ್ ಆ ರೀತಿ ಹಲ್ಲೆ ಮಾಡಿದ ಚರಿತ್ರೆಯನ್ನು ಪ್ರಾಸ 1 ಚಿಕ್ಕಪ್ಪ ಕೊಟ್ಟರು. ಪ್ರಾಸ 1 ಪ್ರತ್ಯೇಕವಾಗಿ ಹೇಳಿಕೆ ಕೊಟ್ಟಿಲ್ಲ. ಮುದ್ದೆಮಾರು ವಂಶಕಡೆಯಿಂದ ಕುತ್ತಿಗೆ ಹಿಂಭಾಗಕ್ಕೆ ಹೊಡೆದರೆ ಮೂಳೆ ಮುರಿಯುವ ಸಾಧ್ಯತೆ ಇರುತ್ತದೆ. ಆದರೆ ಪ್ರಾಸ 1 ಅವರಿಗೆ ಹರಿದ ಗಾಯ ಮಾತ್ರ ಆಗಿರುತ್ತದೆ. ಬಾಗಿಲಿಗೆ ಹಾಕಿದ್ದ ಹರಿತವಾಗಿರುವ ತಗಡುಗಳನ್ನು ಹಾಕಿದರೆ ನೀತಿ 1ರಲ್ಲಿ ಕೊಟ್ಟ ಗಾಯಗಳು ಆಗುವ ಸಾಧ್ಯತೆ ಇರುವುದಿಲ್ಲ. ಪ್ರಾಸ 1 ರವರಿಗೆ ಅನುಕೂಲ ಆಗಲಿ ಎಂದು ಆ ರೀತಿ ಹೇಳುತ್ತಿದ್ದೇನೆ. My submission to this honorable court, the lacerated wound to be found on the neck of the victim. So, to that effect, the witness has clearly stated. Since there is no fracture of the neck bone, my humble submission to this honorable, that is grievous hurt is not caused. To that extent, my humble submission to this 326 will not attract.
PW 18, doctor has said that the injuries were grievous in nature. You have not denied the same.
But previous, my humble submission to this one was okay. As far as 326, to attract 326 is concerned, the latest citations also the position of law is concerned. Fracture of the
Fracture is not mandatory. There are 5 categories under what circumstance
Yes.
an injury can be considered as grievous.
but
Irrespective of the same, a doctor who has examined and treated the injured himself has classified the injury, identified it as grievous
Yes.
in nature.
I am
Even for namesake also, we have not denied that.
yes, yes, that is the the part of the defense evidence that I do. But I am much, I am very much relied on the evidence of PW 11 to that effect.
Hmm.
Now, as far as 354 is concerned, 354 is concerned. 354 is concerned. Assault or criminal force to woman with intent to outrage her modesty.
Hmm.
The assault is not disputed. Whether that assault is caused any outraging the modesty of the victim, that has to be gathered from the evidence. My humble submission to this one, except PW 1 and 2, PW 2 also, on hearing the screaming voice, she come to the spot. The other eyewitnesses said to the prosecution, PW 3, 5, and 8, they have said to be the eyewitness to the incident. They have not supported the case of prosecution with regard to the nature of the incident that took place. So my humble submission to this, to that extent, 354 will not attract. And as far as the section 11,
Now, why 354 is not attracted? I
The-
couldn't follow you.
the eyewitnesses, witnesses that to have been ocularly witnessed, termed by the prosecution PW3, PW5, and PW8, they would have been the right witnesses. What actually the incident that took place, where exactly the incident happened, whether it is a public place or not. The incident took place ಅವರ ಮನೆಯ ಶೌಚಾಲಯದ ಹೊರಗಡೆ ಬರುವಾಗ ಆಗಿದೆ ಅನ್ನೋದನ್ನ ಹೇಳಿದ್ದಾರೆ ಸುದ್ದಿ. When that being the case, my humble submission to this honorable 354 will not attract. Holding her in public view, that is the specific line forthcoming in the charge, third line of the charge with regard to 354. So to that extent, my humble submission to this honorable court, 354 will not.
Whether such ingredients are in the section 354?
So,
Whether such ingredients are in the section 354?
354 public ಅನ್ನೋದನ್ನ ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ. Whoever assaults or uses criminal force to any man intending to outrage or knowing it to be likely that he will thereby outrage her modesty shall be punished with imprisonment of either description for a term which shall not be less than 1 year, but which may extend to 5 years. While going through in between the lines of section 354, the word the public ಅನ್ನೋದು ಎಲ್ಲೂ ಬಂದಿಲ್ಲ. But my humble submission to this honorable court, outrage the modesty ಅನ್ನುವ text ಅನ್ನ ಯೂಸ್ ಮಾಡಬೇಕಾದ್ರೆ the incident should have been taken in public. The public should have viewed thereby her modesty would have been outraged. That has to be gathered from the case. That is my.
And if such incidents have taken place inside a building or house or something else, does it not amount to section 354? If such incident had happened
Yes.
inside the house
Yes.
or any building, whether the section 354 doesn't attract.
That
So
outraging
there is
modesty,
intention to outrage the modesty.
outrage,
Doesn't make any difference whether it is inside or outside the house.
outraging the modesty, in general has to be understood that by the act of the accused, any act of the accused, the modesty
The
of the.
definition itself says, section 2 itself says, what is the outraging the modesty?
Yeah.
There is no question of whether it had occurred inside the house or
Inside out. But to substantiate the outrage of modesty, since the prosecution witnesses turn hostile, eyewitnesses turn hostile to the case of prosecution, my humble submission to this honorable court, prosecution.
According to learned HCGP,
Yes.
when PW1 was assaulted
Yes.
in front of the lavatory,
Yes.
opposite to which lavatory at a distance of 10 feet, there was
Yes.
a public road on which the publics were moving
Yes.
or expected to move.
Yes.
Since the incident has happened in the morning at about 10 o'clock.
Yes.
So behaving with a girl in such a manner in public view and assaulting her
Yes.
itself is outraging her modesty.
To
Modesty is outraging modesty includes inter alia hurting the feeling of
feeling of them.
women. How do you overcome?
To my reply will be.
So you consider that it amounts to hurting the feeling of the women.
Yes. My reply will be. My reply will be.
You said yes. ಅವರ ಮನೆಯವರಿಗೆ ತಿಳಿಸ್ರಿ ಆಮೇಲೆ ಸಾಯಂಕಾಲ ಮನೆಯವ್ರ ಜೊತೆಗೆ ಮಾರ್ಕೆಟ್ಗೆ ಅಂತ ಹೋದಾಗ ಅವರು ಹೊರಗಡೆ ಒಂದು ಶೋಕೇಸ್ ನಲ್ಲಿ ಬಟ್ಟೆ ಅಂಗಡಿ ಅಂದ್ರೆ ಶೋಕೇಸ್ ನಲ್ಲಿ ಬೊಂಬೆಗೆ ಕುಡಿಸಿರೋ ಸೀರೆ ನೋಡಿರಿ ಬಹಳ ಚೆನ್ನಾಗಿದೆ ಸೀರೆ ಕೊಡಿಸ್ರಿ ಅಂತಾರೆ. ನೀವು ಮನೆಯಲ್ಲಿ ಇರೋದು ವಾರ್ಡ್ರೋಬ್ ನಲ್ಲಿ ಇರೋದು ಫಸ್ಟ್ ಖಾಲಿ ಮಾಡು ನಡಿ ಮುಂದೆ ಅಂತೀರಿ. ಯು ಹ್ಯಾವ್ ಹರ್ಟ್ ಅವರ್ ಫೀಲಿಂಗ್ ಇನ್ ಪಬ್ಲಿಕ್. ಯು ಹ್ಯಾವ್ outraged her modesty.
To establish the outrage of the modesty, though the incident apart from the 10 feet from the place of incident, there is a public road. The prosecution has not adduced any evidence of the independent public to substantiate that by the side of the road we have witnessed the incident. That will be our submission.
Yes.
Now, coming to section 11(4), read with section 12 of POCSO Act. Repeated acts that to have been caused, threatening, and such other acts caused by the accused will attract section 11(4), subclass 4, read with section 12 of the POCSO Act. To substantiate that allegation, the prosecution and even the complainant has very much relied on exhibit P3's endorsement said to have been given by the police in respect of the police caught the accused and warned him about his repeated acts. I would like to draw your lordship kind attention.
What is that? Can you repeat that, please? When he was warned, and what is that document of the evidence?
Exhibit P3.
Exhibit P3.
P3.
Whether Exhibit P3 is about the warning the accused about he misbehaving with the girl?
ವಿರುದ್ಧ ನೀಡಿದ ಸಂಬಂಧ ಉಭಯಕ್ಕೂ ಮುಚ್ಚಾಯ ಮಾಡಿ ಹೇಳಿಕೆ ದಾಖಲು ಮಾಡಿದೆ. ಎದುರು ಅರ್ಜಿದಾರರಿಗೆ ನಿಮ್ಮ ತಂಟೆ ತಕರಾರಿಗೆ ಬರದಂತೆ ಎಚ್ಚರಿಕೆಯನ್ನು ನೀಡಿದೆ. ಹಾಗೆಯೇ ಎದುರು ಅರ್ಜಿದಾರರ ತಂಟೆ ತಕರಾರಿಗೆ ಹೋಗದಂತೆ ನಿಮಗೆ ಸೂಚಿಸಿದೆ. So the crucial point of to be considered by this honorable court is
You are misconceiving that particular document. That is with respect to PW2,
PW2
complaint filed by her.
complaint filed by her
Hmm.
say that exact the version of complaint
Hmm.
arises out of this endorsement that is not marked by the
Exactly.
by the prosecution
Alleged complaint is not produced.
produced.
Hmm.
But to substantiate section 11(4) and 12, the complaint is very much relied on this document.
Complainant is relying upon the evidence of PW1, page 2 in the lower portion. ಬೆಂಗಳೂರಿನಲ್ಲಿ ಓದುತ್ತಿದ್ದಾಗ ಪದೇ ಪದೇ ಚುಡಾಯಿಸುತ್ತಿದ್ದ.
ಅದನ್ನ ಹೇಳಿ ನಂತರದಲ್ಲಿ ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೋದು. ಎಕ್ಸಿಬಿಟ್ P3 ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಪ್ರಕಾರ ಅಕ್ಯೂಸ್ ನ ಕರೆಸಿ ಪೊಲೀಸರು ಅವರಿಗೆ ತಾಕೀತ್ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದನ್ನ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು. My humble submission to this honorable court that endorsement is dated 21/2016. Exhibit P3. The incident is of the year 2013, 27/12/2013. So this endorsement particular does not support the argument advanced by the prosecution or either the complainant that the accused has repeatedly interfered or disturbed the victim either any means, that means threatening or following her. To the substantiate that will not help the case of prosecution. Now, the only charge remains is with regard to 307. So my endeavor will be, my humble submission to this honorable court, after the accused was being convicted for the offence under section 324, he has not challenged against the conviction in respect of 324. Now the prosecution has and the complainant has come up with this appeal. Now the evidence on record. Before I advance my argument, I would like to stress the line in wordings in between the lines of 307. Kindly, 307. Attempt to murder.
Yes.
Shall I proceed with the question?
Yes.
Whoever does any act with such intention or knowledge, comma, then it starts and under such circumstances that if he by that act caused death, I will stop here. Thereafter the penal explanation is there. So knowledge ಆದ್ಮೇಲೆ comma ಹೇಳಿದ್ದಾರೆ. Thereafter the words are continued end ಅಂತ ಹೇಳಿದ್ದಾರೆ. So the requirement for punishing an accused under section 307 is not only the intention or knowledge on the part of the accused that by using the force he is going to commit the murder. However, and under such circumstances that if he by that act caused death, so acting that the victim should lead to the end of death. Death ಆಗಲೇಬೇಕು ಅಂತಿಲ್ಲ, to death ಅಂತ ಹೇಳಿದ್ರು. My humble submission to this honorable court, I will not again trouble your lordship by going through the evidence of PW 1 and 2. I would like to rely on the evidence of the doctor to that effect, whether the act caused by the accused would result in commission of death or not. If I establish that the injuries caused or the assault being caused by the accused does not result in death, my humble submission to this honorable court, the prosecution has no case with regard to the offence under section 307.
Injury is not important. is it?
Injury is not important. Intention.
Whether the doctor has given some other
Attempt.
opinion,
Attempt.
If won 302
Yes, yes.
World Cup.
Yes, that's why.
If fail in attempt, runner up 307.
Yes, no. That's why the second line I have stressed about knowledge of the common. Then it starts end and so my humble
for
submission
that
is-
you have to refer the clauses of section 300 of IP. When it about, whether
Yes,
he had a
yes,
knowledge,
Yes,
not only intention, he must have a knowledge that by assaulting with such a weapon, death is likely to cause.
likely to cause them. Yes.
Three
So
not
my
three.
humble submission to this honorable court, if the evidence led by the prosecution with regard to the medical evidence adduced by the prosecution established that the injuries are the assault inflicted by the accused results to death. If that is not established, the prosecution has no case with regard to 3 months. That is my investigation. To substantiate the same, I am relying on the evidence of the doctors. PW. First, I would, as I have already canvassed my argument with regard to the evidence of PW 11, I will not again go. Now, the evidence of PW 18.
Yes.
PW. Dr. Khalid. Now, the second para is ದಿನಾಂಕ 27/12/13 ಡಾಕ್ಟರ್ ಪವನ್ ಕರಿಷ್ಮಾ ಬಾನು ಬಿ ಅನ್ಸರ್ ಪಾಷಾ ಬನಪ್ಪನದೊಡ್ಡಿ ಅವರನ್ನು ಅದೇ ದಿನ ಬೆಳಿಗ್ಗೆ 11ಕ್ಕೆ ತನ್ನ ನೆರೆಮನೆಯ ಹುಡುಗ ತನಗೆ ಹಲ್ಲೆ ಮಾಡಿದ ಎಂಬ ಚರಿತ್ರೆಯಲ್ಲಿ ಚಿಕಿತ್ಸೆಗೆ ತಂದಿದ್ದರು. ಸದರಿ ಪವನ್ ಸದರಿ ಗಾಯಾಳುವಿಗೆ ಆದ ಗಾಯವನ್ನು ಎಂಎಲ್ಸಿ ರಿಜಿಸ್ಟರ್ನಲ್ಲಿ ನಮೂದು ಮಾಡಿದ್ದರು. ಸದರಿ ಗಾಯಾಳುವಿಗೆ ಕತ್ತಿನ ಬಲಭಾಗದಲ್ಲಿ ಊತದ ಗಾಯ, ಕತ್ತಿನ ಹಿಂಭಾಗದಲ್ಲಿ ಕೆಲವು ಆಳವಾದ ಹರಿದ ಗಾಯಗಳು ಆಗಿದ್ದವು. ನಾನು ಎಂಎಲ್ಸಿ ರಿಜಿಸ್ಟರ್ ನಲ್ಲಿ ಪವನ್ ನಮೂದು ಮಾಡಿದ ಗಾಯಗಳ ಆಧಾರದ ಮೇಲೆ ನೀಪಿ 19 ಕೊಟ್ಟಿದ್ದೇನೆ. ನೀಪಿ 19ರಲ್ಲಿ ಕಾಣಿಸಿದ ಗಾಯಗಳು ತೀವ್ರ ಸ್ವರೂಪದವು ಹಾಗೂ ಅವು ಮುದ್ದೆಮಾಳು ಒಂದರ ರೀತಿಯ ಕೊಡಲಿಯಿಂದ ಹೊಡೆದರೆ ಆಗುವ ಸಾಧ್ಯತೆ ಇರುತ್ತದೆ. ಸದರಿ ಭಾಗದಲ್ಲಿ ಸರ್ವಿಕಲ್ ಬೋನ್ ಹಾಗೂ ವೇಲ್ಸ್ ಇರುವುದರಿಂದ ಹಾಗೂ ಆಳವಾದ ಹರಿದ ಗಾಯ ಆಗಿದ್ದರಿಂದ ಸದರಿ ಗಾಯಗಳನ್ನು ತೀವ್ರ ಸ್ವರೂಪದ ಗಾಯ ಎಂದು ನಿಯೋಜಿಸುತ್ತೇವೆ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ಗಾಯಾಳು ಕರಿಷ್ಮಾ ಬಾನುವನ್ನು ನಾನು ವೈಯಕ್ತಿಕವಾಗಿ ಚಿಕಿತ್ಸೆ ಮಾಡಿಲ್ಲ. ಎಂಎಲ್ಸಿ ರಿಜಿಸ್ಟರ್ ನಲ್ಲಿ ಗಾಯದ ವಯಸ್ಸನ್ನು ನಮೂದು ಮಾಡಿರಲಿಲ್ಲ, ಹಾಗಾಗಿ ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ಗಾಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ನಾನು ಕ್ಷಕಿರಣಗಳನ್ನು ಪರೀಕ್ಷೆ ಮಾಡಿಲ್ಲ. ಒಬ್ಬ ವ್ಯಕ್ತಿ ಕುಳಿತಾಗ ಒಮ್ಮೆಲೆ ಎದ್ದಾಗ ತಗಡಿನ ಚೂಪಾದ ವಸ್ತು ತಗಲಿದರೆ ನೀತಿ 19ರಲ್ಲಿನ ಕತ್ತಿನ ಹಿಂಭಾಗ ಆದ ಗಾಯ ಆಗುವ ಸಾಧ್ಯತೆ ಇರುತ್ತದೆ. ಆದರೆ ಎಲ್ಲಾ ಗಾಯಗಳು ಆಗುವುದಿಲ್ಲ. ಯಾವುದೇ ಹರಿತವಾದ ಆಯುಧದಿಂದ ಹೊಡೆದರೆ ಹರಿದ ಗಾಯ ಆಗುತ್ತದೆ, ಆಳಗಾಯ ಆಗುವುದಿಲ್ಲ. ಮುದ್ದೆಯ ಮಾರು ಒಂದರ ಕೊಡಲಿಯನ್ನು ನೋಡಿ ಆ ಸಮಯದಲ್ಲಿ ಪರಿಶೀಲನೆ ಮಾಡಿಲ್ಲ. ಹಲ್ಲೆಯ ಚರಿತ್ರೆಯನ್ನು ಯಾರು ಹೇಳಿ ಬರೆಸಿದ್ದಾರೆ ಎಂದು ಗೊತ್ತಿಲ್ಲ. ನಾನು ಪೊಲೀಸ್ ಕೋರಿಕೆ ಮೇರೆಗೆ ನೀತಿ 19 ಕೊಟ್ಟಿದ್ದೇನೆ. ಪೊಲೀಸಿಗೆ ಅನುಕೂಲವಾಗಲಿ ಎಂದು ನೀತಿ 19 ಬರೆಸಿದ್ದಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾವು if the evidence of PW 11 and 18 is read together, your lordship has to judiciously appreciate the fact that though the evidence is forthcoming with regard to the injuries being previous in nature, the prosecution failed to elicit from the mouth of prosecution that whether the said injuries are likely to cause death or not. that suggestion was not being put to the either PW 11 or PW 18. That is the crux of the case.
ಹೇಳಿದ್ದಾರೆ ರೀ ಯಾರೋ ಒಬ್ರು ದಟ್ ಮೇ ಲೀಡ್ ಅಂತ PW11 ಹೇಳಿದ್ದಾರೆ ನೋಡಿ.
Second paragraph.
ಮುದ್ದೆಮಾಲು ಒಂದರ ಕೊಡಲಿಯಿಂದ ಹೊಡೆದರೆ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಮರಣ ಹೊಂದುವ ಸಾಧ್ಯತೆ ಇರುತ್ತದೆ.
ಮುದ್ದೆಮಾಲಿಂದ ಹೊಡೆದರೆ ಸಾಧ್ಯತೆ ಇರುತ್ತೆ. That I am not disputing. The nature of weapon used for the now by the injuries caused result in death or not. That is required.
Injury is not necessary to attract section 307 ಅನ್ನೋದು ರಿಪೀಟೆಡ್ಲಿ ಹೇಳ್ತಿರ್ಬೇಕಾದ್ರೆ ವೆದರ್ ದಿ ಇಂಜುರಿ ಕಾಸ್ಡ್ ಇಸ್ ಸಫಿಷಿಯಂಟ್ ಟು ಕಾಸ್ ಡೆತ್ ಯಾಕೆ ಬರುತ್ತೆ?
Yes, that's why I have very much stressed on the provision of section 307.
ನಾನು ಅದನ್ನ ಲಾಸ್ಟ್ ಟೈಮ್ ನಿಮ್ಮದೇ ಒಂದು ಕೇಸ್ ನಲ್ಲಿ ನೀವು ಆ ಕಡೆ ಸೈಡ್ ನಿಂತ ಒಂದು ಉದಾಹರಣೆಯನ್ನು ಕೊಟ್ಟಿದ್ದೆ ಅಲ್ವೇ, ವಿಲಿಯಂ ಟೆಲ್ದು. ವಿಲಿಯಂ ಟೆಲ್ ಬಿಟ್ಟು ಬಾಣ ಆಪಲ್ ಏನೋ ಹೊಡೀತು, ಅದು ಅಪ್ಪಿ ತಪ್ಪಿ ಕುತ್ತಿಗೆ ಬಿದ್ದಿದ್ರೆ ಏನಾಗ್ತಿತ್ತು?
But my humble submission is my reply will be, since the prosecution while examining the either PW11 and PW18 has not put the suggestion to the effect that the injuries caused are going to result the death, my humble submission to this on the report 307 will not. And apart from that, in the evidence of PW1 and 2, your lordship has to appreciate the fact they have deposed about the further treatment being taken. She was inpatient for 1 week and she was being again taken to remands. Kindly, I would like to draw your lordship kind attention to exhibit P12 and 13, inpatient record and MLC.
Yes.
Exhibit P. Case sheet is there.
Yes.
Exhibit P12.
Yes.
There, consent for examination, those things are forthcoming. Unlike earlier, date of admission 27/12/2013 amount deposited. Thereafter, 28/12/2013 patient was discharged. I hope your lordship got it. Subsequently, if your lordship go through with the subsequent pages, the doctor has not either made any entry with regard to the patient be referred to higher hospital or follow-up treatment. That is not good. If any such likelihood of the injuries results in causing death, the doctor would have been referred the victim to the higher treatment at Nimans or for follow-up treatment. Since those things are not
Why are you presuming all those things?
not presuming. Based on the documents exhibit P12 and P13 and 14.
Mr. Counsel,
Yes, sir.
P12 clearly says the discharge was against medical observation.
Yes, sir.
Against medical observation.
Yes.
The patient was referred to a higher center by PW18. Holy Christ Hospital said in ನಮ್ಮ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಆಗಲ್ಲ, ಪೇಷಂಟ್ ಕಂಡೀಷನ್ ಎಲ್ಲ ನೋಡಿದ್ರೆ ನೀವು ದೊಡ್ಡ ಆಸ್ಪತ್ರೆ ಕರ್ಕೊಂಡು ಹೋಗ್ರಿ. ಆಮೇಲೆ ಜನನಿಗೆ ಕರ್ಕೊಂಡ್ ಬಂದಿದ್ದು. ಹಾಗಾಗಿ ಜನನಿ ಮತ್ತೆ ಹೈಯರ್ ಸೆಂಟರ್ಗೆ ಕಳಿಸ್ಬೇಕಂತ ಇಲ್ಲ.
the evidence of PW2, it was elicited that subsequently she referred the victim to the Nimans for hair.
ನಿಮ್ಯಾನ್ಸ್ ಬಗ್ಗೆ ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ.
So, that is
ನಿಮ್ಯಾನ್ಸ್ ಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಅನ್ನೋದಕ್ಕೆ ಯಾವ್ದು ಆಕೆ ಸೆಲ್ಫ್ ಸರ್ವಿಂಗ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬಿಟ್ರೆ ಬೇರೆದೇನಿಲ್ಲ.
even the Janani hospital records also does not reveal about the victim being again subjected for any further higher treatment.
ಅದು ಬರಲ್ಲ, ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೇನೆ, ನೀವು ಅದನ್ನೇ ಕನ್ಸ್ಯೂಮ್ ಮಾಡ್ತೀರಿ. ಡಿಸ್ಚಾರ್ಜ್ ಅಗೇನ್ಸ್ಟ್ ಮೆಡಿಕಲ್ ಅಡ್ವೈಸ್ ಅಂದ್ರೆ ಹೈಯರ್ ಸೆಂಟ್ರಿಗೆ ಕಳ್ಸೋದ್ ಬೇಡ, ನಮ್ಮ ಹಾಸ್ಪಿಟಲ್ ನಲ್ಲಿ ಎಲ್ಲಾ ಫೆಸಿಲಿಟಿ ಇದೆ, ಅವ್ರು ಇರಾದೆ. ಹಾಗಾಗಿ ನಮ್ಮಲ್ಲಿ ಇನ್ನೂ ಟ್ರೀಟ್ಮೆಂಟ್ ಕಂಟಿನ್ಯೂ ಆಗ್ಬೇಕು ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರೆ, ಬೇಡ ಸ್ವಾಮಿ ನಾವು ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಿ ಕರ್ಕೊಂಡು ಹೋಗ್ತೀವಿ ಅಂತ ಅವ್ರ ಅಮ್ಮ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ. ಅದ್ರ ಅರ್ಥ ಇವ್ರ ಹಾಸ್ಪಿಟಲ್ ಫೆಸಿಲಿಟಿ ಇರ್ಲಿಲ್ಲ ಅಂತ ಆಗ್ಲಿ, ಅಥವಾ ಇವ್ರ ಹಾಸ್ಪಿಟಲ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಆಗದೆ ಇರೋಷ್ಟು ಅಸಾಧ್ಯವಾದ ಗಾಯ ಆಗಿತ್ತೋ ಅಥವಾ ಇಲ್ಲವೋ ಅಂತ ಆಗ್ಲಿ ಅಲ್ಲ. ಈ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ ಪ್ರಕಾರ ಶಿ ವಾಸ್ ಸ್ಟಿಲ್ ಅಂಡರ್ ಟ್ರೀಟ್ಮೆಂಟ್. ಡಾಕ್ಟರ್ ಪ್ರಕಾರ ವಾಸಿ ಇನ್ನೂ ಆಗ್ಲಿಲ್ಲ, ವಾಸಿ ಆಗಲ್ಲ ಅಂತಲೂ ಅವ್ರು ಹೇಳಲ್ಲ, ಅಥವಾ ಬೇರೆ ಕಡೆ ಕರ್ಕೊಂಡು ಹೋಗಿ ಅಂತಲೂ ಇನ್ನೂ ಹೇಳಿಲ್ಲ. ಸ್ಟಿಲ್ ಶಿ ಇಸ್ ಅಂಡರ್ ಟ್ರೀಟ್ಮೆಂಟ್. ಅಗೇನ್ಸ್ಟ್ ದಿ ಮೆಡಿಕಲ್ ಅಡ್ವೈಸ್ ಶಿ ವಾಸ್ ಟೇಕನ್ ಬ್ಯಾಕ್ ಬೈ ಹರ್ ಮದರ್. ಸೊ ಇಟ್ ವಾಸ್ ಎ ಡಿಸ್ಚಾರ್ಜ್ ಅಗೇನ್ಸ್ಟ್ ಮೆಡಿಕಲ್ ಅಡ್ವೈಸ್. ಆಗಿರ್ಬೇಕಾದ್ರೆ ಹೈಯರ್ ಸೆಂಟರ್ ಕರ್ಕೊಂಡು ಹೋಗ್ರಿನ ರೆಫರೆನ್ಸು ಅಥವಾ ಇಂಥದ್ದು ಟ್ರೀಟ್ಮೆಂಟ್ ಬೇಕು ಅದು ನಮ್ಮಲ್ಲಿ ಇಲ್ಲ ಅನ್ನೋದ್ ಬಗ್ಗೆ ಒಂದು ಅಬ್ಸರ್ವೇಷನ್ ಅದು ಯಾವುದು ಬರೋದೇ ಇಲ್ಲ ಕೇಸ್ ಶೀಟ್ ಅಲ್ಲಿ.
That is my line of submission.
No, your line of argument must be in line.
But the evidence adduced by the prosecution to substantiate that the injuries result to death was not being established. That is sufficient. That is my submission. So my precise argument is to attract the 307 to punish the accused under section 307 of IPC. There is no sufficient evidence being adduced by the prosecution, considering the evidence of PW11, PW18, and the medical records exhibit P11, P12, P13, and 14. And since the term hostile in the case of prosecution also, that will not substantiate the case of prosecution. That is that I will conclude here.
You reply.
My learned friend stated the date balance. ಇಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ, ಈ ಕೋರ್ಟಿನಿಂದ ಈ ಕೇಸಿನಿಂದ ಸಂಬಂಧ ಬಂದ, ನಾಟ್ ಟಾಕಿಂಗ್ ಅಬೌಟ್ ದ ಇನ್ಸಿಡೆಂಟ್ ಆದಾಗ ಈ ಕೋರ್ಟ್ ಈ ಕೇಸ್. ಮೈ ಲರ್ನ್ ಡೇಟ್ 2016 ಅಂತ. ಮೈ ಲಾರ್ಡ್
ಈ ಕೇಸಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಹೇಳ ಮತ್ತೆ ಹೆಸರ ಬಂದಾಗ ಇನ್ಸಿಡೆಂಟ್ ಪ್ರಕರಣ ಮಾಡುದು.
ಇನ್ಸಿಡೆಂಟ್ ಆಗಿದ್ದು 2013, ಕಂಪ್ಲೇಂಟ್ 2016. I want to correct that statement. This case, usually is on bail matter. ಈ ಕೇಸನ್ನ ಈ ಕೋರ್ಟಿನಿಂದ ಈ ಕೇಸಿನಲ್ಲಿ ಸಂಬಂಧ ಬಂದ ನಂತರ ಆರೋಪಿ ಈ ಕೇಸನ್ನು ರಾಜಿ ಮಾಡಿಕೊಂಡು ಇಲ್ಲದಿದ್ದಲ್ಲಿ ಕೊಂದು ಬಿಡುವುದಾಗಿ ಬೆದರಿಕೆ ಹಾಕಿದ. ಆಗ ನಾನು ದೂರು ಕೊಟ್ಟಿದ್ದೇನೆ. So it is what happens in this particular case. She says one time offender ಎಲ್ಲ ಹೇಳ್ತಾರೆ, ಇದಾದ್ಮೇಲೆ ಹಾಕಿದ್ಮೇಲೆ ನನ್ನ ಹತ್ರ ಬಂದು this is what how I wants to it. ಆ ಹಳೆ ಕೇಸಿನ ಬಗ್ಗೆ ಮಾತಾಡ್ತಾ ಇಲ್ಲ. PW2 third page.
So that relevant portion, what you read now, how that helps you? ಈ ಕೋರ್ಟಿನಿಂದ ಈ ಕೇಸಿನಲ್ಲಿ ಸಮನ್ಸ್ ಬಂದ ನಂತರ ಆರೋಪಿ ಈ ಕೇಸನ್ನು ರಾಜಿ ಮಾಡಿಸಿಕೊ, ಇಲ್ಲದಿದ್ದಲ್ಲಿ ಕೊಂದು ಬಿಡುವುದಾಗಿ ಬೆದರಿಕೆ ಹಾಕಿದ್ದ. ಆಗ ನಾನು ದೂರು ಕೊಟ್ಟಿದ್ದೇನೆ. ಈಗ ಸದರಿ ದೂರು ಕೊಟ್ಟ ಬಗ್ಗೆ ಸ್ವೀಕೃತಿ ಪತ್ರ ಹಾಜರು ಮಾಡುತ್ತಿದ್ದೇನೆ. ಅದನ್ನು ನಿಶಾನೆ P3 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಅದು ನಿಮ್ಮ ಅನುಕೂಲಕ್ಕೆ, ನಿಮ್ಮ ಅಸಿಸ್ಟೆನ್ಸ್ಗೆ ಹೇಗೆ ಬರುತ್ತೆ? It's a, if at all that is true, but that is a subsequent event. Subsequent conduct of the accused, whether can be taken to decide the alleged previous guilt for which he is charged. ಹಾಗಾಗಿ ಎಕ್ಸಿಬಿಟ್ P3 ಅಪ್ಲೈ ಆಗಲ್ಲ ಅಂತ ನೀವೇ ಹೇಳ್ತಿದ್ದೀರಿ. ಅದಕ್ಕೆ ಬರ್ಬೋದು, ಅದಕ್ಕೆ ಬರ್ಬೋದು. ಇಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P3 ಅನ್ನೋದು ಬರಲ್ಲ. Assuming that it is true, for the argument purpose, assuming that it is true, that during pendency of this case in the trial court, he might have threatened you. But does it prove the guilt said to have committed by him on a previous year? Conduct of accused. Ashte.
My learned friend has harped upon 326.
So conduct of the accused, what is the relevancy or the place of conduct of accused in a criminal case?
The subsequent conduct after the release of the bail is such, then hearing of sentence. This conduct.
Sentence ಆಯ್ತು, ಇದು to prove the conviction, to prove the guilt, whether the previous or subsequent conduct would be of any material, any evidence. Guilty ಗೆ ಬರಲ್ಲ.
By giving the probation only, the conduct will be. That's it.
ಅದು PO ಆಕ್ಟ್ ಕೆಳಗಡೆ ಅಫೆನ್ಸ್ ಬರೋದಾದ್ರೆ ಅಫೆನ್ಸ್ ಅದಕ್ಕೆ ಅಪ್ಲೈ ಆಗದೇ ಇದ್ರೆ ಪ್ರೊಬೇಷನ್ ಆಫ್ ಅಫೆಂಡರ್ಸ್ ಆಕ್ಟಿಗೆ ಅದು ಅಫೆನ್ಸೇ ಬರಲ್ಲ ಅಂದ್ರೆ ಬರಲ್ಲ. ಸೊ ಪ್ರೀವಿಯಸ್ ಕಾಂಡಕ್ಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಉಮೇಶ್ ರೆಡ್ಡಿಗೆ ಅದು ಒಂದೇ ಸಾಕಿತ್ತಲ್ಲ. ಹೇಳಿ ಹೇಳಿ ಹೇಳಿ.
Intention ಬಗ್ಗೆ, the 307 is very much circumscribed on the intention to kill or not. That has to be gathered from the facts and circumstances of the case. In the case on hand, your lordship will appreciate the fact in the evidence of PW1, PW2 and PW6 part. It is forthcoming that the accused was loving the victim. To that extent, PW1 also stated, even in the cross-examination, when such being the case, whether the accused will take such a stringent step to commit the murder or not, that is also required to be considered.
On the lighter side,
the intention has to be gathered.
On the lighter side,
Yes.
ನೀವೇನಾದ್ರೂ ಕೊಲೆ ಮಾಡುವುದು ಒಂದು ಅಪರಾಧವಲ್ಲ ಅಂತ ಹೇಳಿ ಆಪ್ಷನ್ ಕೊಟ್ರೆ ಪ್ರತಿ ಗಂಡಸರಿಗೂ, ಮದುವೆಯಾದ ವ್ಯಕ್ತಿಗೂ, ನೀನ್ ಯಾರನ್ನ ಫಸ್ಟ್ ಕೊಲೆ ಮಾಡ್ತಿ ಅಂದ್ರೆ ಅವ್ನ್ ಹೇಳದ್ ಇಬ್ರನ್ನೇ, ಫಸ್ಟ್ ಹೆಂಡ್ತಿನ, ಎರಡನೇದು ಅವ್ರ ಅಮ್ಮನ್ನ, ಅತ್ತೇನಾ? ಹಾಗಾಗಿ ಲವ್ ಅಂತಿದ್ರು ಅದೇನಿದ್ರು ಪ್ರಿಯರ್ ಟು ಎಂಗೇಜ್ಮೆಂಟ್. ಎಂಗೇಜ್ಮೆಂಟ್ ಆದ್ರ ಮೇಲೆ ಮದುವೆಗೆ ಬರೋದ್ರೊಳಗೆ ಸ್ವಲ್ಪ ಹೊರಟೋಗಿರ್ತದೆ. ಏನೋ ಆಗಿಬಿಟ್ಟಿದೆ, ಇನ್ವಿಟೇಷನ್ ಕಾರ್ಡ್ ಪ್ರಿಂಟ್ ಆಗಿದೆ, ನನ್ಗೆ ಸೂಟು ಕೊಟ್ಟಿದ್ದಾರೆ, ಈಗ ಬೇಡ ಅನ್ಲಿಕ್ಕೆ ಆಗಲ್ವಲ್ಲ ಅಂತ.
Adding to my submission.
Yes, please.
The whole evidence of PW1, 2 and 6 relies on the earlier case in which the owner of the accused, the victim and mother are required to give evidence.
Yes.
To substantiate that,
Yes.
the prosecution has not adduced or not marked any such iota of document with regard to PW1 and 2 going to give the evidence. That was not being done by the prosecution. So, the facts and circumstances of the case, what I have understood from the case, from the evidence is that since the father and mother of the victim retracted to agree for the marriage of the victim with the accused would have with an intention or revenge on the father and mother of the victim, he tried to assault on the victim. That I have left while arguing, placing my.
No. Are you putting this totally opposite to your own defense?
No, defense. What I am trying to convince you.
The defense was that, your defense was that you intended to marry.
I intend, the accused intended to marry. There is no intention on the part of the accused to commit the murder. To that extent, he has caused the assault. Being ಅವರು ಒಂದ್ ಸ್ವಲ್ಪ ಆ ವಿಷಯದಲ್ಲಿ ತಲೆ ಕೆಡಿಸ್ಕೊಂಡು, ನಾನು ಈ ಹುಡುಗಿನ ನನಗೆ ಸಿಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಆ ತಲೆಯಲ್ಲಿ ಇಟ್ಕೊಂಡು he would have made an attempt to assault. To that extent, 307 attacked. So that is my end. Since the prosecution has not adduced the evidence with regard to the PW1 and 2 going to give evidence in respect of the owners of accused, being accused, for which the accused is said to have threatened the victim, since the prosecution has not given any documentary evidence, that since the accused, the father and mother have not given willingness, they have done this as a
ಕೂತ್ಕೊಳ್ಳಿ. Connected appeal is one by the state, another by the complainant. Victim. Victim, mother of the victim, mother of the complainant. Victim. Summary of the case of the prosecution. Was that the alleged victim, PW1 bracket CW1 Karishma, is a native and resident of PW1. Native and resident of Basapanaduddi village in Kollegala Taluk within the limits of complaint police station. However, for her studies, few years she was at Bengaluru. During that time, the accused had sent her a message over cell phone stating that he is loving her. After return to her village, Basapanaduddi, the accused stated that it was him who had sent the said message, and thereafter, both the accused and the victim started talking to each other. The person complaint and ಮೇಲೆ henceforth called as victim ಅಂತ ಹಾಕ್ಬೇಕು. ಇದೆಲ್ಲ ರೆಗ್ಯುಲರ್ ಆಗಿ ಬರ್ತದೆ, ನಾನು ಪ್ರತಿ ಸತ್ಯ ಹೇಳಲ್ಲ. Thereafter, the accused asked the victim to convince her parents to withdraw a case said to have been filed by them against one Sri Jamir Beg and Jamil Beg, who were said to be the employers of the accused. However, the victim was hesitant to ask her parent to compromise the matter. In that regard, the complainant, the accused threatened the complainant that if she doesn't accede to his request, he would not only avoid marrying her, but also kill her. However, the victim had ignored the said warning of the accused. That being the case, on the date 27/12/2013, at about 10 to 10:30 a.m., while the victim was coming out from the lavatory of her house, the accused, holding a axe in his hand, inflicted 3 blows upon the backside of her neck and another blow on her chest, inflicting injuries upon her. Screaming at the assault made by the accused, the complainant, the victim, fell down. Her mother, bracket PW2, who had rushed to the spot, after seeing the incident, shifted the doctor with the help of others to the hospital and got her to hospitals and got her medically treated. In the hospital, the complainant gave a complaint against the accused. In the hospital, exhibit P1. The victim gave a complaint against the accused. As per exhibit P1, which was registered in complaint station, crime number 180/2013 against the accused for the offence punishable under section 354, 307 of Indian Penal Code. After investigations, the complaint police have filed charge sheet against the accused. For the offences punishable under section 354, 307 of Indian Penal Code. ಮತ್ತೆ ಇದೆಲ್ಲ ಯಾವಾಗ ಬಂತು ರೀ? ಪಾಕ್ಸೋ ಎಲ್ಲ ಯಾವಾಗ ಬಂತು? ಚಾರ್ಜ್ ಶೀಟ್ ನಲ್ಲಿ ಅದಿಲ್ಲ.
ಆಗಲೇ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಆರ್ಡರ್ಸ್ ಏನಾದ್ರು ಮಾಡಿದ್ದಾರೆ?
ನಿಮ್ಮನ್ನ ಕೇಳ್ತಾ ಇರೋದು ಚಾರ್ಜ್ ಏನಾಗಿದೆ ಅಂತಲ್ಲ, ಬೇಸಿಕ್ ಥಿಂಗ್ಸ್, ಬೇಸಿಕ್ ಕ್ವಶನ್ ಕೇಳ್ತಿದ್ದೇನೆ. ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ ಇರೋದು, ಚಾರ್ಜ್ ಶೀಟ್ ನಲ್ಲಿ ಇರೋದು ಒನ್ ಟೈಪ್ ಆಫ್ ಅಫೆನ್ಸ್. ಚಾರ್ಜ್ ಶೀಟ್ಗಿಂತಲೂ ಜಾಸ್ತಿಯಾಗಿ ಚಾರ್ಜ್ ಆಗಿದೆ. ಅದಕ್ಕೆ ಕಾರಣವೇನು? ಆ ಹಿನ್ನೆಲೆನ ನಿಮ್ಮಲ್ಲಿ ಯಾರೂ ಹೇಳಲಿಲ್ಲ. ಅದು ನೀವು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅವರು ವಿಕ್ಟಿಮು ಹೇಳಲೇಬೇಕಾಗಿತ್ತು. ಮಾಡಲ್ಲ, ಹೋಮ್ ವರ್ಕ್ ಮಾಡಲ್ಲ, ಬಹಳ ಈಸಿಯಾಗಿ ಬರ್ತೀರಿ. ಪ್ರಾಬ್ಲಮ್ ಅದು. ಕಮಿಟಲ್ ಆರ್ಡರ್ ಕೊಡ್ರಿ. ಕಮಿಟಲ್ ಆರ್ಡರ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಅಷ್ಟೇ ಮಾಡಿರುತ್ತೆ ಮತ್ತು ಇದರಲ್ಲಿ 7 ಅಲ್ಲದೆಯೇ ಫೋಕ್ಸ್ ಆಕ್ಟ್ ಇರೋದ್ರಿಂದ ನಾನು ಮಾಡ್ತಿದ್ದೇನೆ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಇಲ್ಲ ಅಂದ್ರೆ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಇಂದಲ್ಲಿ ನೋಡ್ಬೇಕು ನಾವು. ಕೇರ್ ಬಿಫೋರ್ ಚಾರ್ಜ್ ಏನಿದೆ ಬೇಸಿಕಲಿ ಕೇಸು ಶುರುವಾಗಿ ಇರೋದು ಚಾರ್ಜ್ ಶೀಟ್ ಏನಿದೆ ಅನ್ನೋದನ್ನು ನೋಡಲ್ಲ. ಏನು ಅಫೆನ್ಸ್ ಅಂತ ಇದೆ ಅಂತಲೂ ನೋಡಲ್ಲ. ಚಾರ್ಜ್ ಮಾಡಿ ಬಿಟ್ಟಿದ್ದಾರೆ. ಎರಡೇ ಕಮಿಟಲ್ ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಸಾಹೇಬ್ರಿಗೆ.
ಅಕ್ವಿಟಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಫುಲ್ ಹೇಳಿದೆ. ಅಕ್ವಿಟಲ್ ಅಂದ್ರೆ ಆರ್ಡರ್, ಫೈನಲ್ ಆರ್ಡರ್. ಅಕ್ವಿಟಲ್ ಈಸ್ ಅಕ್ವಿಟೆಡ್ ಆಫ್ ದಿ ಫಾಲೋಯಿಂಗ್ ಆಫೀಸರ್ಸ್ ಫುಲ್ ಎಲ್ಲ
ಇಲ್ಲದಿಲ್ಲ, ಚಾರ್ಜ್ ಅಲ್ಲಿ ಬಾಕ್ಸ್ ಇದೆ. Charge sheet was filed for reference so. ಅಲ್ಲಿ ಬ್ರಾಕೆಟ್ ನಲ್ಲಿ ಹಾಕೊಂಡಿದ್ದು ಬೋಲ್ಡ್ ಅಲ್ಲಿ ಆಮೇಲೆ ಹೇಳ್ತಾನೆ ಮೆನ್ಷನ್ ಇದು clearing the accused on charge and attracting other offences with 326 IPC and section 11(4) read with section 12 of POCSO Act and framing the charge for those offences. ಆಮೇಲೆ accused pleaded not guilty ಅಂತ ಆಮೇಲೆ ಬರ್ತದೆ. ತೊಂದರೆ ಇಲ್ಲ. ಈಗ ಬ್ರಾಕೆಟಿಂಗ್ ತೆಗೀರಿ. After committal of the matter, in CC number 184/2014 from the Court of Additional Civil Judge in JMF State, Kollegal, the matter was made over to the fast track court. Fast track court, Kollegal. And was registered under SC number 50/2014. During the pendency of the said case before the court, by the prosecution through a memo, it was brought to the notice of the fast track court that the alleged incident attracts even section 11(4) read with section 12 of the POCSO Act, and a request was made to make over the case to the special court. After hearing the learned presiding officer of the fast track court, Kollegal, by his order dated 16/1/2015, Order for transfer of the case to the jurisdictional special court, Chamarajanagar. Accordingly, the matter came up before the special court on so ಬಂದಾಗ PDJ court ಅಂತಾರೆ. Special court ಆಮೇಲೆ PDJ. ನಮ್ಮ ಹೆಚ್ಚಿಂದ ಹಾಗೆ ಆಗ್ತದೆ. ಯೂನಿವರ್ಸಿಟಿ ಕೇಸ್ಗಳು ಫಸ್ಟ್ ಟ್ರಿಬ್ಯುನಲ್ ಬರಬೇಕು. ಅವ್ರೇನಿಲ್ಲ ಸೀನಿಯರ್ ಸಿವಿಲ್ ಜಡ್ಜ್ 7 senior civil judge court so and so place ಅಂತ ಹಾಕ್ತಾರೆ. Actually that is tribunal. Illi he may be PDJ court, but that is special court. Special court so and also PDJ. But accordingly, the matter came up before. The court of the Principal District and Session Judge Chamarajanagar, which is also a special court. Under POCSO Act and was renumbered as special case number 12/2015. After hearing both sides so the charges were framed for the offense so ಅದೆಲ್ಲದು ನಂತರ ಫಾರ್ಮೆಟ್ ಪ್ರಕಾರ ಬರಲಿ. ಅದರಲ್ಲಿ ಇರ್ತದೆ. ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡಿಂಗ್ ಯಾರಿದ್ರು It's judgment dated so and so ಅಂತ ಹೇಳಿ ಬರ್ತದೆ ರಿಸೈಟ್ ಅನ್ನು ಫಾರ್ಮ್ಯಾಟ್ ನಲ್ಲಿ. The special court, though acquitted the accused of the offences punishable under sections so and so. However, it convicted the accused for the offence punishable under section 324 of IPC and sentenced him accordingly. Aggrieved by the same, the victim has tried. Victim has preferred appeal in criminal appeal 1786/2017 and the state has preferred an appeal in criminal appeal 491/2017. In both the appeal, the accused was originally accused as a respondent was originally being represented by his learned counsel. Since the learned counsel for the accused public respondent in both the appeal remained absent on several days of hearing. This court by its detailed order dated 10/11/2023. Appointed amicus curiae. Appointed learned counsel Shri V.S. Vinayaka as amicus curiae for the accused in both the appeal. Simultaneously, noticing the continuous absence of the learned counsel for the appellant in criminal appeal 1780/2017 also. 1786 of 2017. Simultaneously, sentence in the
Simultaneously noticing the continuous absence of the law conflict
appellant in criminal appeal 1786 of 2017 also. On the very same day, this court appointed learned counsel Srimati K.M. Archana as amicus curiae for the victim oblique appellant in criminal appeal 1786/2017. Consequently, the learned counsels who were earlier appearing for the appellant in criminal appeal 1786/2017 and the learned counsels appearing for the accused in both the appeal stood relieved in the matter. So 1786 ಅಂದ್ರೆ ಒಂದು ಅಪೀಲ್ ಹಾಕಿದ್ದಾನೆ ಅಂತ ಅಡ್ವೊಕೇಟ್ ಇರ್ತಾರಲ್ಲ. ನಲ್ಲಿ respondent remained absent. ಇನ್ನೊಂದರಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಇರ್ಬೋದು.
ಇನ್ನೊಂದರಲ್ಲಿ ಇರ್ಬೋದು ಸ್ವಾಮಿ. 490 ಇದೆ.
ಯಾರು ಓದಿ ಇದು ಅಲ್ಲಿ ಆ ಸೆಂಟೆನ್ಸ್ ಚೇಂಜ್ ಮಾಡಿ ಅಲ್ಲಿ ಇನ್ criminal appeal 1786/2017 the accused who was respondent number 1 though served but remained unrepresented. However, in criminal appeal 491/2017 where the accused was the sole respondent, he appeared through his counsel and was being represented by his counsel. However, the said learned counsel for the accused in criminal appeal 491/2017 since has remained absent for few dates of hearing. This court by its detailed order dated 10/11/2027 appointed 10/11/2023 appointed learned counsel Shri V.S. Vinayaka as amicus curiae for the accused public respondent in both the appeals. Simultaneous. Continue. Last stood relieved. Continue. Heard arguments from both sides of the legislature. The learned HCGP for the appellant oblique state in criminal appeal 491/2017 in her argument submitted that the evidence led by the prosecution, more particularly the evidence of PW1 and 2, shows that at the time of commission of the offense, the accused not only had the knowledge but also the intention to take away the life of the victim, since he had threatened in express terms to PW1 that he is going to kill her in case if she doesn't accede to his request of pursuing her parents from withdrawing a case filed by them against his employers. It is with the said intention, since he has inflicted multiple blows with the axe at MO1, the offense punishable under section 307 Indian Penal Code has been established. She further contended, relying upon output judgment relying upon it. Sadakat Kotwara ನಿಮ್ಮದು ದೊಡ್ಡದಾಗಿ ಬರೀಬೇಕು. ನೀವು ಸೈಡ್ ಚಿಕ್ಕದಾಗಿ ಬರೆದ್ರೆ ಆಗಲ್ಲ. ನಾನು ಮುದುಕ ಇದ್ದೇನೆ, ನಿಮ್ಮಷ್ಟು ಹೆಂಗಲ್ಲ. ಏನ್ ಬರಲ್ಲ ಅವರಲ್ಲಿ.
ನೋಡ್ತೇವೆ ಸರ್.
Relying upon the judgment of Honorable Apex Court in Sadakat Kotwar and another versus State of Jharkhand reported in 2021 SEC Online SC 1046. The learned SCGP submitted that where the weapon used is deadly weapon, and the injury inflicted on vital parts of the body, the offense squarely attracts section 307 of Indian Penal Code. The SCGP further contended that since the offense has been committed in front of a lavatory facing a public road during broad daylight against a minor girl, the accused has committed the offense of outraging the modesty of the victim. Further, the evidence of prosecution that the victim was minor on the date of the offense has not been denied by the accused anywhere. Further, the evidence led by prosecution, more particularly of PW1 and PW2, go to show that prior to the date of incident, on several occasions, the accused was sending SMS messages and teasing the SMS messages to the victim, stating that he was loving her and was teasing her and following her while she was pursuing her studies at Bengaluru. As such, section 11 bracket small Roman 4, read with section 12 of POCSO Act also stands established. However, the trial court, without appreciating the evidence placed before it in its proper perspective and without giving any reasons, has only noticed the injuries inflicted upon the victim by the accused, and by itself concluding that they were simple in nature, has acquitted the accused of the offense punishable under section 307, 326, 354 of IPC and under section 11(4), read with section 12 of POCSO Act, which is erroneous. As such, the impugned judgment warrants interference at the hands of this court, and appeal deserves to be allowed. Learned amicus curiae for the appellant in criminal appeal 1786/2017. In her argument, apart from adopting the points canvassed with the learned CGP, also has submitted that the evidence of PW1 and PW2 as a victim to the incident and eyewitness to the incident have come in a uniform manner and has withstood the detailed cross-examination from the accused side. Both of them have clearly stated that it was accused and accused alone who inflicted multiple grievous injuries upon the victim. The trial court mistook the grievous injuries, though stated by PW18, the doctor, as simple in nature, and ignored the fact that the proven guilt not only attracts section 326 of IPC, but also section 307 of Indian Penal Code. Learned counsel further contended that in order to attract section 307 of Indian Penal Code, it's not always necessary that there must be grievous injuries on the part of the victim. However, suffice if intention or knowledge on the part of the assailant is proved. In her support, she relied upon a judgment of Honorable Apex Court in the case of State of Madhya Pradesh versus Harjit Singh and others, reported in Manu SC 0238/2019. Adela citations correct and nodi haki. Further contending that the further contending better. So case and also same point. The judgment of Honorable Apex Court in SK Kaja versus the State of Maharashtra, criminal appeal number 1183/2011, dated 23/8/2023. Learned counsel further, learned amicus curiae further contended that all the ingredients, all the essentials of section 307 IPC has clearly been made out by the prosecution through the cogent evidence of PW1, PW2, corroborated by the medical evidence. However, the special court, and mail in brevity in the throughout special court and matter was referred to special court, which was renumbered and so on so bantala. Alinda munde for brevity special court. However, the special court, without appreciating the evidence in the proper perspective, in few sentences, observed that the proven guilt attracts only section 324 IPC, but not the other offences. Learned amicus curiae for the victim further contended that the age of the victim as on the date of the incident was only 17 years, and the same has not been denied or disputed from the accused side. The evidence of PW1 shows that the accused was teasing her and sending uncommon messages. Obscene ಅಂತ ಕರೀಲಿಕ್ಕೆ ಆಗಲ್ಲ. Obscene ಅನ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. Uncommon messages ಬೇಡ, obscene messages ಅಂತಲೇ ಹಾಕಿ. ಅದು ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್. Obscene messages. Obscene messages, knowing fully well that she was minor in her age. As such, in section 11(4), read with section 12 of Pox Act also has to be proved. The forensic science laboratory report along with the serology report have clearly established the presence of blood stain on the dress materials worn by the victim at the time of incident and also on the weapon, that is X at MO1. It is established that the group of the blood found on the weapon and the dress material worn by the victim was matching with the blood group of the victim, which is B positive. As such, both through oral evidence and through documentary evidence, scientifically also, the prosecution has proved that the accused has attempted to kill PW1 by inflicting multiple injuries upon her through the weapon at MO1. The said weapon also has been identified by none else than the victim herself, and the photograph of the scene of offense also shows the presence of the said weapon in it. However, the trial court, without considering all these vital, all these important and clinching evidence, has straight away jumped to the conclusion that though the act of the accused in assaulting the victim has been established, but the same cannot be considered as an act of attempting to cause death of the victim, resulting in acquitting the accused from the major offense of section 307 IPC and under section 11(4), read with 12 of POXO Act. As such, the interference by this court is warranted by allowing the appeal filed by the complainant. Learned amicus curiae for the accused in both the appeals, in his argument, at the outset fairly considered that according to his information, the accused has not preferred any appeal against the impugned judgment. He submitted that the nature of the wound said to have been sustained by the victim in the alleged incident are simple in nature as stated by PW11, the doctor. PW11 PW11, the doctor, where the victim was said to have been taken treatment as an inpatient. Further, the very same doctor has also stated that if the injuries with the MO1 are inflicted with force, then there was all the possibility of the fracture of the cervical bone, which in the instant case has not occurred. As such also, it cannot be held that the accused had any intention to kill PW1. Thus, the trial court has the special court has rightly acquitted the accused of the offense punishable under section 307 of Indian Penal Code. He further contended that the prosecution has utterly failed to prove that the alleged act of the accused in any manner, in any way, can be called as outrage in the modesty of a woman. Since the act of assault and act of outrage in the modesty of the women are two different offences requiring two different offences. With this is submitted that since the trial court has, after appropriate analysis of the evidence, has rightly acquitted the accused of the offences punishable under section 307, 326, 354 of Indian Penal Code and under section 11(4) read with 12 of POCSO. The same doesn't warrant any interference at the hands of this court. Other points for consideration. One, whether the prosecution has proved beyond reasonable doubt charge to be. That on the date 27/12/2013 at about 10:30 AM, in front of a lavatory in the house of PW1. Whether in all the offences under POCSO, the name of the victim must be concealed or only with respect to section 4, 6, 8 and 21. All the offences. Other rules I also of the impression that for any offence under POCSO, Rule 4. Rule 4 ಅಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
Article before preliminary. And the history of the for development of the child that these are her right to privacy and confidentiality be protected and respected by every person by all means. And
ಅಲ್ಲ ಅದು ಆಬ್ಜೆಕ್ಟ್ ಆಯ್ತು, ಇದು ಆಬ್ಜೆಕ್ಟ್ ಆಯ್ತು. ಸೆಕ್ಷನ್ 33 ನಲ್ಲಿ ಹರ್ ಐಡೆಂಟಿಟಿ ಕೆನಾಟ್ ಬಿ ಡಿಸ್ಕ್ಲೋಸ್ಡ್ ಅಂತಾನೆ ಹೇಳಿದ್ದಾರೆ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ. ಅದು ಡ್ಯೂರಿಂಗ್ ದಿ ಟ್ರಯಲ್ ಅಂದಿದ್ದಾರೆ. ಎಸ್ ತಗೊಳ್ಳಿ. ಏನ್ ತಗೊಂಡ್ರಿ? The prosecution has proved beyond reasonable doubt that on the date 27/12/2013 at about 10:30 a.m. while CW1, the victim, being a minor girl, had been to nature call to the lavatory in her house at P2 Kudi. In the house in Basapanaduddi village, Kollegala Taluku, within the limits of compliant with the police station. The accused with an intention to outrage with accused why the victim was coming out from the lavatory. Assaulted her and voluntarily caused grievous hurt by dangerous weapon, that is an axe, and inflicted injuries on her neck and chest, and thereby committed an offence punishable under section 326 of Indian Penal Code.
Recording the reasons, it can be disclosed by the.
By recording the reasons, necessity idre ಮೊನ್ನೆ ಕೇಸಲ್ಲಿ ಬಂತು ನೋಡಿ, ನಾನು ಇಂಥವ್ಳು ಪಬ್ಲಿಕ್ ನೋಟಿಸ್ ಕೊಟ್ಟು ಇಂತಹ ವ್ಯಕ್ತಿ ಮೆಸ್ಕಾನ್ ಇಂಜಿನಿಯರ್ ನನ್ನ ಶೀಲಹರಣ ಮಾಡಿ ಮದುವೆ ಶೀಲಹರಣ ಮಾಡಿದ್ದಾನೆ, ಹಾಗಾಗಿ ಈ ವ್ಯಕ್ತಿಯ ಬಗ್ಗೆ ಜಾಗರೂಕರಾಗಿರಿ ಅಂತ ಅವಳೇ ಪಬ್ಲಿಕ್ ನೋಟಿಸ್ ಕೊಟ್ಟು ನ್ಯೂಸ್ ಪೇಪರ್ ಅಲ್ಲಿ ಹಾಕ್ಸಿರ್ಲಲ್ಲ, ಅಂಥದ್ದೇನಾದಿದ್ರೆ ಸ್ಪೆಷಲ್ ಕೊಟ್ಟು ಅದನ್ನು ಮೀಡಿಯಾಕ್ಕೆ ಏನಾದ್ರು ಹೇಳ್ಬೇಕು, ಅದು ಬೇರೆ ಜನಗಳಿಗೆ ಗೊತ್ತಾಗ್ಬೋದು ಅಂತ ಮಾಡುದು. Whether the prosecution has proved beyond reasonable doubt that on the date, time and place mentioned above, the accused assaulted CW1, the victim, intending to outrage and knowing that his act would be likely that he will thereby outrage her modesty, has committed an offence punishable under section 354 of Indian Penal Code. 3. Whether the prosecution has proved beyond reasonable doubt that on the date, time, and place mentioned above, the accused assaulted CW1, the victim, with an axe on her neck and chest with an intention to cause the death of CW1, the victim, and knowing that under the circumstances his act may cause her death, in which case he would be guilty of murder, has inflicted injury upon, has assaulted, inflicted injury by has assaulted CW1 and thereby has committed an offence punishable under section 307 of Indian Penal Code. Or whether the prosecution has proved beyond reasonable doubt that on the date, time, and place mentioned above, by his act of following the accused, following CW1, the victim, and teasing her, and also sending her lustful messages and CW1 victim ಅಂತ ಬಂತ ಇದರಲ್ಲಿ has committed an offence punishable under section 11(4) read with section 12 of POX. Interference is the warrants in interference. ಅದು ಮಧ್ಯಾಹ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ಈ ಪಾಯಿಂಟ್ಸ್ ಅಷ್ಟು ಏನ್ ಹೇಳಿದೆ ಪಾಯಿಂಟ್ಸ್ ಅಷ್ಟೊಂದು ಟೈಪ್ ಮಾಡಿ ಮಧ್ಯಾಹ್ನ ಯಾರು ಬರ್ತಾರೆ ಹೇಳಿ. ಹಾ ಹಾ ಈಗ ಬರ್ತಾ ಇಲ್ಲ. We are not publishing. That is clear in section 33, 23(2). Section, whether IPC refers to POXO, POXO can refer to IPC.
ಮೇಡಮ್ ಅದು ಬರ್ಕೊಳ್ಳಿ ಹೇಳ್ತೀನಿ. SEC ಅದರದ್ದು ರಿಪೋರ್ಟೆಡ್ ಜಡ್ಜ್ಮೆಂಟ್. 2019 ವಾಲ್ಯೂಮ್ 20 SEC 524. ಕಾಪಿನೂ ಬೇಕಾ? ಬೇಡ, ಸುಮ್ಮನೆ ಬೇಜಾರಕ್ಕೆ ಬರ್ಕೊಳ್ಳಿ. ಬಂದಿದೆಯಮ್ಮ ನಿಮಗೆ ಇವರು ಅರ್ಚನಾಕ್ಕೆ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ರೆಫರ್ಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ. ಅದನ್ನ ಕರೆಕ್ಟ್ ಆಗಿ ನೋಡ್ಕೊಂಡು ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಸೈಟೇಷನ್ ನೋಡ್ಕೊಂಡು ಹಾಕಿ ಕರೆಕ್ಟ್ ಆಗಿ ಅಂದ್ರಲ್ಲ. ನಿಮ್ಗೆ ಎಲ್ಲಿ ಕೊಡ್ತೀವಿ ನಾವು ಈಗ? ಹಾ, ಈಗ ಟೈಪ್ ಮಾಡಿ ಕೊಡ್ಬೇಕಲ್ಲ ನೀವು. ಹಾ ಸರ್, ಯಾವ್ದು? ಹಾ ಹಾ, ಬರೀ ಅಪೀಲ್ ಕೊಟ್ಟಿರೋದು ಖಾಜಾ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್. ಹಾ, ಏನದು? ಇದೆ ಸರ್, ಬರ್ದ್ಬಿಡ್ತೀನಿ ಇಲ್ಲ. ಹಾ ಹೇಳಿ ಸರ್. ಹಾ ಹಾ, 1093. ನಿಮ್ಗೆ ನೆಟ್ ಸಿಗತ್ತೀವಲ್ಲ ಹುಡ್ಕೋಕೆ ಸರ್. ತಗಣೆ ಅಷ್ಟು ತಗೊಂಡು ಕೊಟ್ಬಿಡಿ ಅಂತ ಅವ್ರಿಗೆ. ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Session continues. Yes. ಅದಾದ ಎಲ್ಲೆಲ್ಲಿ ಇಕ್ತಾರೆ ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ.
ಚಂದ್ರಗ್ ಓದ್ಬೇಕ್ಯಾ? ಫೈಲ್ ನಾವು ಮಧ್ಯಾಹ್ನ ಸೈನ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ.
ಹೇಳಿ ಸರ್. ಬನ್ನಿ ಏನ್ ಹೇಳಿ, ಅಷ್ಟೇ ಕೇಳಿಸ್ತಿಲ್ಲ ನನ್ಗೆ. ಹಾ, ಫಾಲ್ಸ್ ಪ್ರಾಮಿಸ್ ಟು ಮ್ಯಾರಿ.
Continuation of the list, fill number 3.
Reported check. SCC. SPP ಅವ್ರು ಕೊಟ್ಟರೆ SCGP ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಒಂದು ಕೊಟ್ಟಿದ್ದವರು SCGP ಅವ್ರು ಒಂದು ಕೊಟ್ಟರು, KM ಅರ್ಚನಾ ಅಪ್ಲಿಕೇಶನ್ 2 ಕೊಟ್ಟರು.
According to prosecution, both the accused and the victim were the resident of Procedural village and they knew each other since prior to the incident. The said aspect is not disputed from the accuser's side. On the other hand, the said aspect is stated by PW1 and PW2 in their evidence, which has not been denied by the accused. Moreover, the accused himself by taking a contention in the form of his defense by making suggestions to PW1, PW2 and PW6 to that effect, has shown that the victim was a person known to him and that he was loving the victim. However, the parents of the victim were not willing to give her in marriage to him. Though PW1, PW2 and PW6 have denied this suggestion that due to the alleged non-acceptance, due to the alleged denial of consent to the marriage, a false, due to avoid, due to the alleged, due to avoid the marriage of the victim with the accused, a false case has been filed by them through PW1. However, the evidence that accused and the victim and her family were known to, accused and the victim were known to each other, has remained undenied. Furthermore, PW1 has stated that after the initial incident of accused sending her a message to her cell phone as "I love you," thereafter they started talking with each other and the same resulted in one loving the other, has not specifically denied from the accused side. PW2, the mother of the victim, also had spoken about the said love between accused and the victim. However, the same was what she claims to have heard from her daughter, that is the victim. About the incident that have taken place on 27/12/2013. Among the 19 witnesses examined by the prosecution, it is PW1, PW2, PW3, PW4, PW5, PW6, PW11, PW18 and PW19 are shown to have stated about the same. Among the above witnesses, even though PW3, CW so and so, name so and so, PW4, CW so and so, name so and so, and PW5, CW so and so, and name so and so, were shown by the prosecution as the persons rushing to the spot of the incident immediately after hearing the screaming of PW1 and seeing the accused in the place and also the weapon. However, all these three witnesses have pleaded their total ignorance about the incident. As such, the prosecution couldn't get any support from these three witnesses. Even after treating them as hostile and subjecting them to cross-examination, the prosecution could not get any support from them. Where PW1, CW1, the victim, In her evidence about the, in her evidence after stating that while she was studying at Bengaluru, during her high school days, while she was studying in a high school at Bengaluru, she received a message as "I love you," and subsequently after her return to her village, she came to know that it was the accused who has sent the message, and admitting the same, the accused started loving her, and both of them decided to marry. Has about the incident proceeded to state that, on the date of 27/12/2013, in the morning at about 10:30, while she was coming out from the lavatory of the house, the accused assaulted her on her neck 3 times with an axe and assaulted on her chest 1 time, due to which assault she fell down. Her mother, CW 3 to 5, rushed to the spot. Having seen those persons rushing to the spot, the accused, by throwing the axe which he was holding, ran away from the place. Thereafter, she was shifted in an auto rickshaw to Holy Christ Hospital at Kamagiri, and after getting the first aid treatment there at the advice of the doctor, she was shifted in an ambulance to Janani Hospital at Kollegala. The witness, in specific term, has stated that with an intention to kill her, the accused had assaulted her in such a manner. She also stated she was inpatient in the said hospital at Kollegala for a day, at which time the police visiting her had recorded a statement which she has identified at Exhibit P1. She also clarified that due to her immobility of the limbs, she could not put her signature to the said complaint. However, has put her thumb mark on it, stating that she can also identify the weapon used by the accused in assaulting her. The witness has identified an axe which was marked at MO1. She also stated that due to the assault made by the accused, the dress worn by her at the time of incident got blood stained. Those dress materials those cloths were collected by the doctor. Stating so, the witness has identified a veil, pajama, chudidar top, an innerwear like a banian and a bra, which are marked from MO2 to MO6 in the court. Further stating that the incident took place near the door of the lavatory. The witness has identified a photograph at exhibit P2 as the one showing the place of the offense. Seeing a X in the said photograph fallen on the ground, she had stated that it was the X which was marked at MO1. This witness was subjected to this witness with a paramedic. PW1 was subjected to a detailed cross-examination from the accused side, wherein she adhered to her original version. In her cross-examination, she gave more detail about the incident and the love affair between her and the accused. She stated that though the accused has agreed to marry her, however, her family members were not agreeable for the same. She clarified in her cross-examination that though there were adjacent houses as neighbors, however, at the incident, they did not came to the spot, but her mother came. She specifically stated that with an intention to kill her, the accused has assaulted her. CW2. Umera Banu, the mother of the victim, has stated ಅದರಲ್ಲಿ ಇದನ್ನು ತಗೊಳ್ಳಿ ಹಿಂದಿನರಲ್ಲಿ ಒಂದು ನಿಮಿಷ. It is not in dispute ಅಂತ ಬಂತು ನೋಡಿ ಫಸ್ಟ್ ನನ್ನ ಪ್ಯಾರ.
CW1 was subjected to.
ಅಲ್ಲ ಫಸ್ಟ್ ಪ್ಯಾರ ಈಗ ಡಿಟೇಷನ್ ಶುರು ಮಾಡಿದ್ವಿ ಇನ್ ದ ಕೇಸ್ ಆಫ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ದಟ್ ದೇ ನೋ ಈಚ್ ಅದರ್. ಆ ಫೈಂಡಿಂಗ್ ಆ ಪ್ಯಾರ ಎಂಡಿಗೆ ಬನ್ನಿ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರ ಏನ್ ಬಂದಿದೆ?
CW1, the victim in the reference.
ಅದಕ್ಕೆ ಮುಂಚೆ ಒಂದು ಇನ್ಸರ್ಷನ್ ಹಾಕಿ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರ. According to prosecution, the victim was a minor as on the date of the alleged offense. PW1 in her examination chief itself has stated that her date of birth is 10/8/1995. 10/8/1996. The same has not been denied in her cross-examination. PW2, Umira Banu, the mother of the victim, also in her examination chief stated that as on the date of the incident, her daughter, that is the victim, was aged 16 to 17 years. Such statement of PW2 also has not been denied from the accused side. More importantly, PW1 ಶ್ರೀಮತಿ ಎ ನಿರ್ಮಲಾ ಗಂಡಸ ಸರ್ ಇವರು Nirmala is a lady or gents? PW1. Vinaya, Vijaya, Santosha. Looking at the name, you cannot determine the sex in these days. Nirmala in her examination, Nirmala, the headmistress of Government Higher Primary School, Vasappana Doddi, in her evidence has stated that at the request of the investigating officer in this matter, she has verified the school records and based upon the details recorded in the based upon the school record, based upon the details recorded in the school record, she has issued a date of birth certificate of the victim who was an alumni of their school. Stating that, certifying that victim, the date of birth of the victim as per the school record was 10/3/1996. In that regard, she has issued a certificate as per Exhibit P14. She further stated that the admission register brought to her by the court in its original also mentions the recording of the date of birth of the victim as 10/3/1996. Stating so, she has produced a copy of the admission register extract. Which copy the special court, after comparing the same with the original register, proceeded to mark it as an exhibit number 15. The witness has identified her signature in both the documents. However, the perusal Exhibit P14, which in fact is a transfer certificate, and Exhibit P15, which is an extract of admission register, which is a copy of relevant section of admission register maintained by the school, go to show that the date of birth of the victim recorded therein is 10/8/1996, but not 10/3/1996. However, since the documents being the photocopies and the ink appearing to be not bright and legible, the date was confusing to be 10/3/1996. As such, though PW told in her oral evidence has stated that as per the school records, the date of birth was 10/3/1996. However, the very same school records produced by the same witness shows the date of birth of the victim as 10/8/1996. The date of birth stated by again is the same. The evidence of PW told that date of birth of victim has been recorded in the school record. Same are reflected. Exhibit P14 and Exhibit P15 has not been denied in the cross-examination of the said witness. Incidentally, the cross-examination of the said witness also appeared to be jumbled, with some portion of the cross-examination of PW11 probably due to keeping the evidence of PW11 as a format in the computer system without deleting the copied portion of the second page, the copied portion of the evidence in the second page of PW11. As such, the continuation of the cross-examination of PW12 in page 2 by a bare reading go to show that it is not of PW12 but of some other witness. The availability of the deposition of PW11 go to show that the contents of page number 2 of PW11 has been copied in page 2 of the cross-examination and page 2 of the deposition of PW12 also. However, neither the witness bracket PW12 nor the presiding officer have noticed it, but they have subscribed their signatures to the said deposition. Still, the fact remains that the say of PW12 that date of birth of the victim girl who was their ex-student is recorded in the school records, the extracts of which are at Exhibit P14 and P15 has been not denied in her cross-examination. As observed above, both Exhibit P14 and Exhibit P15 shows the date of birth of the victim as 10/8/1996. Further, PW1 herself in her examination chief has stated her date of birth as 10/8/1996, which has not been denied in her cross-examination. Thus, it stands proved that the date of birth of the victim is 10/8/1996. As such, as on the date of the alleged offense, which is on 27/12/2013, the victim was aged 17 years, 4 months, 17 days. As such, she was a child under POCSO Act also. ಈಗ ಲಾಸ್ಟಿಗೆ ಬನ್ನಿ. ಲಾಸ್ಟ್ ಎಲ್ಲಿ ನಿಲ್ಲಿಸಿದ್ದೇನೆ? PW2 ಹೇಳ್ಬೇಕು ಅನ್ಸುತ್ತೆ. PW2 ಆಯ್ತಾ? ಹಾ. PW2, CW2, Umair Banu, the mother of PW1, the victim. As stated that on the date of incident, which was on 27/12/2013, her daughter, PW1, had been to lavatory. ಏನಕ್ಕೆ ಬಂದಿದೆ ನಾನು ಇನ್ಸರ್ಷನ್ ಹೇಳುವ ಮುಂಚೆ ಎಲ್ಲಿಗೆ ಎಂಡ್ ಆಗಿದೆ ಆ ಸೆಂಟೆನ್ಸ್ ಓದಿ. ಏಜ್ ಏನದು ಇನ್ಸರ್ಷನ್ ಮಾಡಿದ್ದೇನೆ ನಾನು.
Umair Banu, as also stated in the examination sheet, that as on the date of the incident, on 27/12/2013, she was aged about 60. The said statement of the victim is also denied from the accused side. More importantly, PW told Srimati A. Nirmala, the headmistress of the government higher primary school, Pasaptana Putti, in a letter stated that at the request of PW2 dog.
ಇದೆಲ್ಲದು ಆಗೋದು ನೀವು ಸುಮ್ಮನೆ ರೊಟೀನ್ ಆಗಿ ಬರ್ಕೊಳ್ತಾ ಹೋಗ್ತೀರಿ. ಡಿಕ್ಟೇಷನ್ ತಗೊಳ್ಳೋ ಕ್ರಮ ಏನು ಅನ್ನೋದನ್ನ 98% ಆಫ್ ದ ಹೈಕೋರ್ಟ್ ಸ್ಟಾಫ್ who takes dictation, they do not know. ನಮ್ಮ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜುಡಿಷಿಯರಿಯಲ್ಲಿ ಇರ್ತಾರೆ, ಎಷ್ಟು ಪರ್ಫೆಕ್ಟ್ ಇರ್ತಾರೆ ಗೊತ್ತು. ನೀವೀಗ ಏನು ಓದಿದ್ರಿ ಅದಷ್ಟು ಇನ್ಸರ್ಷನ್ ನಾನು ಹೇಳಿದ್ದು. ಇದಿಷ್ಟು ಆದ್ಮೇಲೆ ನೀವು ಹಾಗೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀರಿ, ಆಮೇಲೆ ಏನೋ ಮಿಸ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡು ಬರ್ತೀರಿ. 3 ದಿವಸ ನಮಗೆ ತಲೆ ಕೆಡ್ತದೆ ಕರೆಕ್ಷನ್ ಮಾಡೋದ್ರೊಳಗೆ. ನೀವು ನಿರ್ಲಿಪ್ತರಾಗಿ ನಿಲ್ತೀರಿ. ನಾವೇನೋ ಟೈಪ್ ಮಾಡಿ ಬಿಸಾಕಿದ್ದೇವೆ, ಅದನ್ನ ರಿಪೇರಿ ಮಾಡ್ಕೊಳ್ಳೋದು ನಿಮ್ ಕೆಲಸ. ಕಂಟಿನ್ಯೂ ಮಾಡಿ. On the date 27/12/2013, ಹೇಳಿದೆ ನೋಡಿ, her daughter PW1 had gone to lavatory at about 10 o'clock in the morning. While she was returning from a shop after purchasing the goods, she saw the accused holding an axe in his hand, moving towards the direction of her house from his house. Being surprised as to why the accused is going towards her house and going towards her house, the two carrying an axe with him, she was looking at that, by which time her daughter came out from the lavatory. While she was bolting the door of the lavatory, the accused went to her and assaulted on her neck with the axe which was holding. He inflicted, while she was seeing, the accused inflicted one more blow upon her. Looking at that, she screamed. CW3 to CW5 also came running to the spot. Having seen PW2 and CW3 to 5 rushing to the spot, the accused threw the axe he was holding in the spot and ran away from there. Thereafter, these people attended to the victim, and getting an auto rickshaw shifted the injured from Basappana Doddi to Holy Cross Hospital at Kamagere. PW2 further stated that she intimated about the incident to her husband, bracket CW4. The doctor at Kamagere Hospital, after giving first aid treatment, advised to take the injured to a higher hospital. Accordingly, the injured PW1 was shifted to Janani Hospital, Kollegala, where she was inpatient for a day. Though doctors at Janani Hospital, the doctors at Janani Hospital suggested to take the injured to other hospital. Accordingly, the injured was taken to Nimhans at Bengaluru and was admitted there. Giving the history to the alleged incident, PW2 has stated that she inquired with PW1, her daughter, in that regard, for which PW1 stated that when she was in her grandmother's house at Bengaluru, one day a message came to her mobile phone as denoted, "Come, I love you." She ignored the such message, which did not have the sender's name. After her return to her village, Basappana Doddi, accused telephoned to her and stated that it was him who had sent her the said message, and also stated that he is loving her. Witness also stated that PW1 consented to the said love as stated to her. This incident has happened about 6 months prior to the incident. Thereafter, the accused was calling her daughter over the phone one day. PW2 PW6 answer. Illi, she informed when Malak sentencing day, she telephoned to her husband, bracket CW4 ಅಂತ ಬರ್ಸಿದ್ದೇನೆ ನೋಡಿ. ಈಗ ಒಂದು 2-3-4 ಸಾಲ ಹಿಂದೆ
Intimated about the incident to her husband, CW4.
ಟು ಅವರ್ ಹಸ್ಬೆಂಡ್ ಅಂತ ಅಷ್ಟೇ ಮಾಡಿ CW4 ಹೊಡೆದಾಕಿ. ಇಲ್ಲಿ ಗಂಡಂದ್ರುಗಳದ್ದು ಸ್ಥಾನ ಪಲಾಟ ಮಾಡ್ತಾರ ಅವ್ರು CW ಎಷ್ಟು ಅನ್ನೋದನ್ನು. ಆಮೇಲೆ ನಮಗ್ ಪಾಪ ಬರುತ್ತೆ. CW6 answer. The father of the victim has stated in his evidence that on the date of incident, he was away from his house on his work. However, he was informed by Rafiq over the telephone that while his bracket of this witness daughter -PW1 was coming out from the lavatory near her house, the accused assaulted her with an axe on her neck. PW2 to PW4 rushed to the spot, and having seen them rushing to the spot, the accused threw the axe at the spot and ran away from there. It is thereafter PW2 to 4 administered water to PW1 and shifted her to hospital at Kamagiri in an auto rickshaw. The witness stated PW4, who had telephoned him, has also stated to him that since the clothes worn by the victim, worn by the injured, are bloodstained due to incident, the other set of cloths were required to be brought. Accordingly, he, taking another set of cloth of his daughter, went to Kamagere Hospital. From there, he went to Janani Hospital and gave clothes to PW1, who changed her dress. PW6 has further stated that in his inquiry with PW1 about the incident, she stated that the accused had sent a message earlier as single-entered comma, I love you. That message was repeated by the accused. Again, it is later on, she came to know that it was the accused who was sending her such messages. After a return to the village from the Bengaluru, the accused, confessing that it was him who had sent this message, has also proposed to marry her. The witness stated that though accused was ready to marry her, initially PW1 was not agreeable to the same. Later, she also agreed to marry him. As such, they were talking to each other over the phone. The witness has further stated that after collecting the bloodstained cloth worn by her daughter at the time of incident, she has produced the same before the investigating officer, who, by drawing a Caesar Panchanama as per Exhibit P8, has seized the same, stating that he would identify the weapon used in the commission of the crime as well the cloth worn by his daughter at the time of the incident. The witness has identified the 8s at MO1 and the cloths at MO2 to MO5. In his cross-examination from the defense, from the accused side, he specifically stated that he was not an eyewitness to the incident. As such, the entire evidence of PW6 about the alleged incident is purely a hearsay based upon what he claims to have heard from one Rafiq, bracket PW4, and his daughter. The evidence of PW1 and PW2 about the incident that accused, who was a person known to them, was loving PW1 as analyzed above, established by the prosecution, since that is one among the defense taken by the accused in the cross-examination of material prosecution witnesses, including PW1 and PW2. The evidence of PW1 that accused assaulted her with an axe on 27/12/2013 while she was coming out from the lavatory near her house. Though had been denied in the cross-examination of the witness by making denial suggestion. However, except making denial suggestion, nothing could be elicited in the cross-examination of PW1 to suspect her evidence regarding the alleged incident. In the above circumstance, the evidence of In the above circumstance, there is no reason to disbelieve or suspect the evidence of PW2. Which evidence inspires confidence in the court to believe? Our Honorable Apex Court, in a case Lakshmana versus so and so, was pleased to observe that even a former candidate, the evidence of a injured witness can be relied upon and convincing candidates upon his offer. But in the other side, as it is. In the instant case, in addition to the evidence of PW1, the evidence of PW2 as an eyewitness also has corroborated the case of prosecution. She has made it clear that she was an eyewitness to the alleged incident. She too has described about she having seen the accused proceeding towards her house, carrying an axe with him, and being surprised she watching as to what accused was doing. However, within no time the accused assaulting her daughter with the very same axe, inflicting injuries upon her. Even in her cross-examination also, except making the suggestions of denial, nothing could be elicited from the accused side to shaken the evidence given by her in her examination in chief. Thus, the evidence of PW1 and PW2 have come in a cogent manner, corroborating each other and giving a uniform and full account of the alleged incident of accused inflicting blows with an axe which was holding at the time of incident. Both the witnesses have identified this at the exact amount 1. The evidence of PW1 as a victim and PW2 as an eyewitness is further corroborated by the evidence of the medical evidence. The prosecution has examined PW11. PW1, but PW18, C bracket CW14, Dr. Khalid. Then CMO of Holy Cross Hospital, Kamagiri. The said witness has stated that one Dr. Pawan, previously working in the said hospital, has examined victim on 27/12/2013, who was brought to their hospital at about 11 a.m. with the history of an assault by a neighbor boy. The necessary entries in MLC register also has been made to that effect. The injured had sustained 19. Conclusions. The injured had sustained contusion over right side of the neck and deep multiple laceration wound over the back of the neck. She had also sustained multiple abrasions. The witness has stated that those injuries were grievous in nature and could have been caused and were possible to be caused when assaulted with the X at MO1. MO1. The witness has given clarification stating that since cervical bone and veins were there in the neck region and the lacerated wounds were deep, he has considered those injuries as grievous in nature. Stating that in that regard, a wound certificate has been issued based on the records maintained by the hospital. The witness has identified the said wound certificate at exhibit P90. Though in his cross-examination from the accused side, he stated that he has not personally treated the injured, but his evidence in examination chief itself is that it was one Dr. Pawan who had treated the injured. However, due to his non-availability, it is him who has given the evidence based on the records maintained by the hospital. The prosecution got examined one Mr. Blaze. ಇವರು ಮಿಸ್ಟರ್ ಮಿಸ್ಸಸ್ ಗೊತ್ತಿಲ್ಲ, ಎಲ್ಲ ಮಾಡ್ತಾರೆ. ಅವ್ರ ಹೆಸರು ಮುಂದೆ ಒಂದು ರೂಲ್ ಮಾಡ್ರಿ, ಯಾವ್ದಾದ್ರು ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಒಂದು ಡೈರೆಕ್ಷನ್ ಕೊಡ್ರಿ, ಎಲ್ಲರೂ ಹೆಸರು ಮುಂದೆ ಅವರೇ ಹಾಕೊಳ್ಬೇಕು ಅಂತ ಶ್ರೀ ಅಥವಾ ಶ್ರೀಮತಿ. ಒಂದು Mr. Blaze, said to be the administrator of Holy Cross Hospital, Kamagere, as PW19. The said witness in his evidence has stated one Dr. Pawan was working in their hospital from 23/12/2013 to 29/12/2013. However, he doesn't know where the said doctor is working now. As per the records maintained by the hospital, on 27/12/2013, the said Dr. Pawan has examined the victim in the case, and a mentioning to that effect is there in the MLC register of the hospital. A police intimation was also given with respect to the said medico-legal case. Stating so, the witness produced a copy of the intimation given to the police and got it marked as exhibit P20, an extract of the MLC register and got it marked as exhibit P21, and his signature therein at exhibit and his signatures in those documents. He also stated that the exhibit P19 was issued by PW18, Dr. Kali, based upon MLC register. He clarified that when the police he also gave information that since they said Dr. Pawan was not available in the hospital, it was Dr. Kali who issued exhibit P19. The evidence of this witness was not cross-examined. This witness was not cross-examined from the accused side. As such, the evidence given by this witness has remained undenied and undisputed and established that the victim after the incident was taken first to Holy Christ Hospital at Kamagere, where treating it as an MLC, she was given first aid treatment, where the doctor has found out the injuries as reflected in the wound certificate at exhibit P19. PW 11 CW 13, Dr. Samson the medical officer at Janani Hospital, Kollegala, in his evidence has stated that in the afternoon of 27/12/2013, when Srimati Umira Banu, the mother of the victim, had brought PW1, the victim with the history of assault with an egg on the victim on that date about 11 a.m. He came to know that the injured was first taken to Holy Cross Hospital. From there, the patient was referred to his hospital. The witness stated that he examined the injured and noticed that she had sustained lacerated wounds at 4 places on the backside of her neck. She had also sustained one more lacerated wound on her chest portion. The victim was admitted as an inpatient in their hospital on 27/12/2013 and got a discharge on the next day afternoon. The witness identified the wound certificate at Exhibit P11, stating that it was issued by him. Wound has issued a certificate in that regard, which he has identified at Exhibit P11. Identifying an extract of a case sheet and getting it marked as Exhibit P12, the witness has stated that the said case sheet pertains to the victim who was treated in their hospital. He also stated that the blood group of the victim was also tested in their hospital, in which regard he has issued a certificate as per Exhibit P30. He further stated that if a person is assaulted with MO1, the injuries mentioned in Exhibit P11 are possible to be caused. In case if the assault is with force by MO1, the assaultee may also die. In his cross-examination from the accused side, the witness gave more details about the treatment given to the injured. Except eliciting further details, nothing could be elicited from this witness in his cross-examination to make his evidence in examination chief a doubtful one. As such, the evidence of PW11 and PW18 further corroborates the evidence of PW1 and PW2 that in the assault committed by the accused upon the victim, she sustained multiple injuries as shown in the wound certificate at Exhibit P19. P19. Further, both PW11 and PW18, after seeing the X at MO1, has stated that if a person is assaulted with the said weapon, the injuries found on the victim and mentioned in exhibit P11 are possible to be caused. Therefore, the nexus between the weapon, therefore, the presence of the injuries on the victim and the nexus between the weapon and the injury stands established from the evidence of these two doctors. The further corroboration placed by the prosecution to prove its case, to prove that it was accused and accused alone has committed the alleged act, that it produced FSL consent marking ಅಥವಾ through investigating officer or prosecutor blood group in the FSL officer.
16.
Hmm.
16.
Has relied upon the forensic science laboratory report, which is at exhibit P7. Go PW15, PW16, M. Shekhar Raju, then ASI of the complaint police station, has spoken about he receiving an MLC from Kamagere Hospital, from Holy Crest Hospital at Kamagere, and recording the statement of PW1 and Kamagere Janani Hospital. Holy Cross Hospital. And recording the statement of the victim at Janani Hospital, Kollegala, and registering a crime in the station, crime number 180/2013, and thereafter submitting an FIR as per exhibit P16 to the court. The next witness, that is PW17 CW22 Basavaraju, who is the investigating officer in the case, has stated about he visiting the spot of the offense and drawing a scene of offense of Panchanama as per exhibit P5, and at that time seizing an axe found fallen in the spot, which is at MO1, and collecting sample mud and blood-stained mud from the spot, which has identified at MO6 and 7. He has also stated that he had requested the doctor to examine the blood grouping of the victim, bracket PW1. Accordingly, the blood grouping of the victim was done and it was ascertained that it was B positive blood. FSL ಗೆ ನಾವು ಕಳಿಸಿದ್ದೇವೆ ಅಂತ ಯಾವ ವಿಟ್ನೆಸ್ ಹೇಳಿದ್ದಾನೆ ಇಲ್ಲಿ? 17. The very same witness has also stated that during the investigation, he has also seized the clothes worn by the victim at the time of the incident under a Panchanama as per Exhibit P8. He sent the seized articles, including the eggs and the clothes of the victim, to the examination to the Regional Forensic Science Laboratory at Mysore. And subsequently has received a report from the said laboratory as per Exhibit P70. CW16, CW15, Dr. Chaya Kumari, the scientific officer at Regional Forensic Science Laboratory, Mysuru, has stated that her laboratory received the articles sent by the investigating officer in this matter, which was 7 in numbers, and subjected them for their chemical examination. After recording the finding of the examination, she has prepared a report as per Exhibit P17 and submitted the same. She has prepared a report as per Exhibit P17 and given it to the investigating officer. The witness has identified the articles at MO1 to MO7 as the articles that were received in her laboratory and examined by her. The said report at Exhibit P17, which has not been denied or disputed, specifically from the accused side, shows that the articles that were sent for the chemical analysis were MO1 to MO7. Among those articles, except in the sample mud mixed with gare pieces, mixed with concrete pieces, all other articles were found stained, which after examination revealed to be blood stains, and it was human blood with B group. Thus, human blood with B group. As observed above, the blood group testing of the victim, the report of which is at Exhibit P13, also shows that it was of B positive, of the group B positive. Thus, the dress worn by the victim at the time of incident and also the eggs said to have been used by the accused in the commission of the crime were all found stained with the victim's blood. Victim's blood. In this victim's blood, this further corroborates the evidence of the victim, eyewitness, as well as the doctor about the incident and the weapon used. As such, it has to be held that the prosecution has proved that it was the accused and accused alone who inflicted injury upon the victim by assaulting her on the date, time, and place mentioned above, comma, with the eggs at MO1. The next question, the next point that would be considered is whether the act of the accused in assaulting PW1 and inflicting 4 injuries can be construed as an act of attempting to commit murder of the victim. Learned HCGP for the state and learned amicus curiae for the victim in their argument vehemently submitted that the very act of the accused vehemently submitted that to attract section 307 IPC, it is not necessary that the injured should have sustained previous injuries. The absence of the injuries also can attract section 307 IPC. Still, in the instant case, the injured victim has sustained 4 lacerated wounds on the vital parts of her body. In Sadakat Kotwar's case, relied upon by learned Sadakat Kotwar's case, bracket supra, relied upon by learned HCGP, the Honorable Apex Court was pleased to observe that use of the deadly weapon and the causing of the injury on the chest and stomach, which are the vital parts of the body, has shown that the appellant has shown that the accused has committed an act of attempt to murder attracting section 307 IPC. However, the said observation was made by the lordship considering the facts and circumstances of the case before it and confining to the same. In Arjit Singh's case, bracket supra, relied upon by learned amicus curiae for the victim, the Honorable Apex Court was pleased to hold that if the assailant acts with the intention or knowledge that such action might cause death and hurt is caused, then the provisions of section 307 of Indian Penal Code would be applicable. It was further observed that there is no requirement for the injury to be on a vital part of the body comma, merely causing hurt is sufficient to attract section 307 of Indian Penal Code. In Rogers case bracket supra, which was also relied upon by the learned amicus curiae for the victim, the Honorable Apex Court was pleased to hold that merely because the injuries sustained by the complainant was simple in nature, that would not absolve the accused from being convicted for the offense under section 307 of the IPC. What is important is an intention coupled with the overt act committed by the accused. A bare reading of section 307 of Indian Penal Code itself makes it clear that to attract section 307 IPT, it is not always necessary that the assaulted should sustain, assaulted oblique victim should sustain some injury. What makes an act of the accused an attempt to murder is his intention or knowledge under the circumstance leading to an act which act, if results in causing the death, would be guilty of murder. Thus, guilty of murder. However, to assess the quantum of the sentence for the proven guilt of attempt to murder, any hurt caused to the victim would augment the quantum of the sentence, would enhance the quantum of the sentence. Thus, the presence of injury upon the victim in the act of attempt to murder would lead in pronouncing a higher sentence in the case where the injury is not sustained by him. As such, presence or the nature of the injury cannot be the sole criteria to decide whether the alleged act attracts section 307 IPC. In the instant case, no doubt, as analyzed above, the prosecution has established that the accused assaulted PW1, the victim, and inflicted 4 injuries upon her. However, merely by the presence of those 4 injuries, it cannot be deduced that the accused attempted to cause the death of the victim. In order to call the act of the accused as an attempt to kill the victim, the other essential ingredient of section 307, which is the knowledge and oblique or intention on the part of the accused, plays a vital role. In the instant case, PW1, the victim, in the instant case, though learned HCGP for the state and learned amicus curiae for the victim vehemently contended that the prosecution has proved the intention behind the alleged commission of crime. However, the learned amicus curiae for the accused in his argument contended that except some allegation regarding the motive, the prosecution has utterly failed to prove the motive. PW1, the victim in her evidence has stated that after she started loving the accused with some reciprocity, the accused, who was working under one Jamir Beg and Jamil Beg, bracket CW7 and 8, asked the victim, asked her to pursue her parents to compromise the matter with said Jamil Beg and Jamil Beg. However, she was scared to request her parents to compromise the matter. Then the accused stated to her that in case if she doesn't pursue her parents to compromise the matter, he would kill her, and also he would not love her any further, and also would not marry her. However, she ignored the same, stating that the accused is merely uttering it without intention to do it. Thus, PW1 attributes that her non-acting as requested by the accused in getting the alleged matter compromised by her parents with one Jamil Beg and Jamir Beg has made the accused to attempt to kill her by inflicting injuries upon her. However, PW1 could not give any details as to which particular case the accused wanted her to compromise. Which particular case the accused wanted her parents to compromise. Similarly, PW2, the mother of the victim also, in her evidence, has stated that they had filed a case in Rampura police station against Jamir Beg, Jamil Beg, Tajmullah, Noor Jan, Mishrad Jan. A court summons also had issued to them in the matter as such on 26/12/2013, which was previous day to the date of the incident. They had been to court at Kollegala. The witness has further stated that as she came to know, the accused had telephoned PW1 and asked her to ask her, bracket this witness, to compromise the matter. Since PW1 kept quiet without doing anything, the accused once again telephoning her threatened her that he would kill her, and also he would not love her and wouldn't marry her. In spite of the same, PW1 just ignored it, thinking that the accused is stating so with no intention to do it. The said motive attributed to the alleged offense by PW2 in her examination chief has not been specifically denied in her cross-examination. Not denied, specifically, but not denied in her cross-examination. The evidence of PW2 about she lodging a case, she filing a case against Jamil Beg and others, and about she attending to the court on 26/12/2033, which is the previous day to the incident in question, and also her evidence that the accused had telephoned the victim asking her to get the matter compromised by convincing her (PW2) have all not been denied in the cross-examination in any manner. As such, the entire evidence of PW2 attributing motive to the act of the accused behind he assaulting victim with MO1 has remained undenied and undisputed. PW6, the father of the victim also, in his evidence, reiterated the summary of what PW2, his wife, has stated regarding the motive behind the commission of crime. This witness also has stated that the accused had exerted pressure upon his daughter (PW1) to pursue her parents to compromise in the said case filed against Jamir and Jamil Ahmad. PW6 has stated that accused was friend of Jamil and Jamil Ahmad. Thus, PW6 also attributed the motive behind the crime, stating that since PW1 did not accede to the request or demand of the accused and ensured the compromise of the case instituted by her parents, he committed the act of assaulting the victim with the axe. The said evidence of PW6 attributing motive to the act of the accused in the commission of the crime has not been denied in his cross-examination from the accused side. Thus, like the evidence of PW2, even the evidence of PW3 also regarding the motive behind the commission of the crime has remained undenied and undisputed from the accused side. This evidence of PW1, PW2, and PW6 makes it clear that the accused was interested in making favor to one Jamir and one Jamil, and in ensuring the compromise of the matter against them, which was said to have been filed against them by the parents of the victim. ಈ ಲಾಸ್ಟ್ ಪ್ಯಾರಾ ಏನ್ ತಗೊಂಡ್ರಿ ಈಗ ಹೇಳ್ತಾ ಇರೋದು, ಈಗ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಲಾಸ್ಟ್ ಎರಡು ಸೆಂಟೆನ್ಸ್ ಲಾಸ್ಟ್ ಪ್ಯಾರಾ ಹೇಗೆ ಶುರುವಾಗಿದೆ ಹೇಳಿ.
This evidence of PW2 makes it clear
this evidence of PW
makes it clear that the accused was interested in making favor to one Jamir and
this evidence of PW2 ಅಲ್ಲ, this evidence of ಎರಡು ಮೂರು ಜನರದ್ದು ಹೇಳಿದ್ದೇನೆ ನೋಡಿ ನಾನು.
PW2 and PW6 makes it clear that the accused was interested in making favor.
PW1, PW2 and PW6 ಎಲ್ಲ ಸ್ಕಿಪ್ ಮಾಡ್ತೀರಿ.
interested in making favor to one Jamir and one Jamil and then.
Continue ಮಾಡಿ. Though said Jamir Beg alias Jamir and Jamil Beg alias Jamil were examined as PW8 and PW9 by the prosecution. However, though both of them have turned hostile and not supported the case of prosecution, but these two witnesses not supporting the case of prosecution is not an unexpected. It is for the reason that generally a person against whom the case is said to have been filed by, a criminal case is said to have been filed by other side and who is alleged to have interested in pressurizing the complainant to influence the matter. Sentence is also not unnatural for the reason. Who the sentence?
It is for the reason, totally a person against.
It is for the reason you mentioned a sentence.
PW8 and PW8, PW9, those who said Jamil Beg alias Jamil Beg were examined as PW8, PW9 by the prosecution. However, though both of them have been turned hostile and not supported the case of the prosecution, but these two witnesses not supporting the case of the prosecution is not unacceptable. It is for the reason joint totally a person against whom a criminal case is said to have been filed, other side and who is alleged to have interested in pressurizing the complainant to compromise the matter.
Thus, irrespective of PW8 and PW9 not supporting the case of prosecution, since the motive attributed by the material prosecution witnesses, more importantly PW2 and PW6, who according to the accused, who according PW2 and PW6, who according to the motive behind the commission of the crime that the accused intended to ensure the compromise in the other criminal case instituted by the parents of PW1, the victim, stands established. Even though the accused attempt to ensure the compromise in a criminal case from the parents of the victim is established, still that itself may not be a foolproof evidence to hold that he intended to kill PW1. The said gap is filled by the evidence of PW1 and PW2, who have specifically and categorically stated that being not happy with the inaction on the part of PW1, the victim, in pursuing her parents to compromise the matter, comma, the accused threatened PW1 that he would not only stop loving her, but also would proceed to kill her. Proceed to kill her. He said statements said to have been made by accused to PW1 has been reiterated both by PW1 and her mother PW2. Further, as observed above, the alleged criminal case filed by the parents of the victim was slated for hearing in Kollegala, in a court at Kollegala on 26/12/2013, which was just the previous day of the incident in question. As observed above, the evidence of PW2 given to that effect has not been denied from the accused side. Therefore, it can be inferred that since on the previous day, the other criminal case where the accused was interested in ensuring a clean chit to either his employer or his friends, that is Jamir Beg and Jamil Beg, would not materialize, he has committed the act of assaulting PW1 on the very next day. That is on 27/12/2013. Full file. In addition to the above, the places of the organ upon which the injury inflicted by the accused upon PW1 also plays an important role in arriving at a finding whether the act of the accused results in attracting section 307 IPC. The para, as observed above, the evidence of PW18 coupled with the wound certificate at Exhibit P19 go to show that PW1, the injured victim, was found sustained with a contusion on the right side of her neck and a deep multiple laceration wound over the back of the neck and multiple abrasions. PW18 has opined all these injuries as grievous by giving the reason that in the neck region, cervical bone and the veins carrying blood were also found. And it is in that place the injury has been inflicted. According to PW1, the victim, and PW2, the eyewitness, the accused was not satisfied with inflicting a single blow on PW1 with the MO1 VX. On the contrary, he inflicted 3 blows on her neck and 1 blow on her chest. Had the accused not intended to take away the life of the victim, he would not have inflicted multiple blows, which in the instant case is 4 blows on the victim. The very act of the accused that he came to PW1 duly armed with a deadly weapon, that is X with a handle, and without talking to her, lodging multiple blows upon her, that too on the vital organ, that is the neck and chest, would clearly go to show that accused was not only known of the consequences of his act, but also had an intention to take away the life of PW1, the victim. However, the special court, without analyzing the evidence placed before it in its proper perspective, merely carried away by the evidence of PW11 that the injuries were simple in nature, and in its single sentence reasoning, observed that since the injuries found on the PW1 were simple in nature, the prosecution has to be treated as failed to prove the offense punishable under section 307 IPC. With the said observation, holding that the prosecution could be able to prove that the accused has assaulted PW1 and inflicted injuries upon her with the X at MO1, identified the said act of the accused as an offense punishable under section 324 of Indian Penal Code. Since the said reasoning given by the special court in the impugned judgment appears to be erroneous in the light of the analysis made above, the impugned judgment warrants interference at the hands of this court. The accused, Kutakali innu ide, innu few pages, it is my judgment, it won't end so soon. The accused has also been charged with the offense punishable under section 326 of Indian Penal Code. In the light of the evidence and in the light of the analysis made above, and more particularly in the light of evidence of PW18, the doctor, that the injuries found on the victim was grievous in nature, and the evidence have further proved that it was the accused who inflicted those injuries with the X at MO1, though section 326 of IPC can also be pressed into service. However, in the light of the accused having found guilty of the offense, since in the light of the observation that the prosecution could be able to prove beyond doubt that the accused has committed an offense punishable under section 307 of Indian Penal Code, no separate observation with respect to section 326 IPC need to be made. Change it. The prosecution has also alleged that in the course of his act towards PW1, the victim, on the date of incident, the accused has also exerted criminal force against her and outraged the modesty of the victim. And HCGP for the state in her argument vehemently submitted that ಈಗ ಬರ್ತದೆ ನಿಮ್ದು admitted that outraging the modesty also includes hurting the feeling of the victim. In the instant case, since accused has assaulted the victim in front of the lavatory of her house, which was hardly 10 feet away from the main road, which was a public place, the prosecution has to be taken as proved the offense against the accused, punishable under section 354 of Indian Penal Code. We are not satisfied with the said interpretation of section 354 of IPC as depicted by learned HCGP. Section 354 of IPC clearly mentions that there must be an assault or use of criminal force to any woman by the accused with an intention to outrage or knowing it to be likely that he will thereby outraging the modesty of the said women. In the instant case, evidence of none of the witnesses, much less PW1, PW2 and PW6 have anywhere whispered that the accused had any knowledge or intention to outrage the modesty of PW1, the victim. No doubt, it is established that the accused has assaulted PW1 with a weapon, that is the X at MO1, and had used criminal force. However, the said use of criminal force or assault no doubt has proved to be with an intention and knowledge, with an intention to take away her life and knowledge about the consequences of his act, but the same would not be taken as an intention to outrage her modesty by the accused. Moreover, nothing has come in the evidence of PW1 about her feeling at the act of the accused. If at all PW1 has felt that her modesty was outraged by the accused, then it was expected of her to speak about the same in her evidence. But nowhere she has whispered. Neither the prosecution nor the court, in the absence of any evidence, either direct or indirect, cannot peep into the mind of the victim and try to find out what her feeling was at the time of incident. Therefore, the argument of 11th HCGP on the said point is not acceptable. Consequently, though the accused was charged for the offense punishable under section 354 IPC, we find no evidence placed by the prosecution to prove the said alleged guilt against the accused. Whereas the accused has also been charged with the offense under section 11 bracket small roman 4 read with section 12 of POCSO.
Already advanced in respect of 11-4. But sufficient to this honorable court kindly PW12. Cross-examination one sentence. I would like to draw your lordship.
PW12.
PW12. ಅಂಗನವಾಡಿಯವರನ್ನು ಸ್ಕೂಲಿಗೆ ಸೇರಿಸುವಾಗ ಜನನ ದೃಢೀಕರಣ ಪತ್ರ ಕೊಟ್ಟಿರಲಿಲ್ಲ.
ಹೌದು.
ಎಸ್. ನಾವು
ಹಾ.
ದೇಶದ ಒಂದು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಅಲ್ಲೇ ನಾವು ಆ ಬಗ್ಗೆ ಒಂದು ಹೇಳಿಕೆ ಪಡೆದಿಲ್ಲ. ಶಾಲೆಗೆ ಸೇರಿಸುವ ಸಮಯದಲ್ಲಿ ಸರಿಯಾಗಿ ವಯಸ್ಸನ್ನು ಹೊಂದಿಸಲು ಸ್ಟಾಪ್ ಆಗಿದೆ. ಅದರಿಂದ I am submission to this honorable court. The admission register extract date, what is mentioned is not the proper document to establish the age of the victim. And adding to that, the investigation officer during the course of evidence, he only gave the requisition to the headmaster to give the birth certificate. Even the IOE also has not tried to collect the original birth certificate of the victim. When such being the case, and adding to that, the doctor has not sent the victim for ossification test to establish the age of the victim. Considering these lacunas on the part of the prosecution, my humble submission to this honorable court is prosecution has not proved the age of the victim. That may be finding.
ಏಜ್ ಬಗ್ಗೆ ಆಲ್ರೆಡಿ ನಾನು ಬರ್ಸಿದ್ದೇನೆ, ತೊಂದರೆ ಇಲ್ಲ. ಈಗ ನಿಮ್ಮ ಪ್ರಕಾರ ಏಜ್ ಪ್ರೂಫಿಗೆ ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಬೇಕಿತ್ತು. ಹಾಗಾದ್ರೆ ನೀವು ಇನ್ನೊಂದು 4 ತಿಂಗಳು ಈ ಪಾಯಿಂಟ್ ಅನ್ನ ಗಟ್ಟಿಯಾಗಿ ಎಲ್ಲರಾದ್ರೂ ಹೇಳಬೇಡಿ. ಇನ್ನು 4 ತಿಂಗಳಿಗೆ ನಾನು ರಿಟೈರ್ ಆಗ್ತೇನೆ, ನನ್ನದು ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ಲ. ಆಮೇಲೆ ಶಾಸ್ತ್ರಿ ಸಾಹೇಬರು ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ಲದಂಗೆ ಸೇರಿ ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲಿ ಕೂತವ್ರ ಪೈಕಿನ ಎಷ್ಟು ಜನಗಳು ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ ಗೊತ್ತಿಲ್ಲ. ಬಹಳಷ್ಟು ಜನಗಳದ್ದು ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅವಾಗಿಲ್ಲ. ಈಗ ಅದನ್ನ ಕಂಪಲ್ಸರಿ ಮಾಡಿದ್ದಾರೆ. 10 ರೂಪಾಯಿ ಫೀಸ್ ಇರೋದನ್ನ ಈಗ ನಿನ್ನೆಯಿಂದ 100 ರೂಪಾಯಿ ಮಾಡ್ಬೇಕಂತ ಇದ್ದಾರೆ. ಫೀಸ್ 10 ರೂಪಾಯಿ ಇದ್ರು ಅದ್ರ ಮೇಲ್ಗಡೆ ಬಕ್ಷೀಸು 1000 ರೂಪಾಯಿ ಮುಂಚಿದ್ಲೂ ಇರ್ತಿತ್ತು. ಅದೆಲ್ಲದು ಬೇರೆ ಪ್ರಶ್ನೆ. ಆದರೆ ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕಡ್ಡಾಯ ಅಂತ ಎಲ್ಲಿಯೂ ಹೇಳಲಿಲ್ಲ. The proof of age of a minor, even under Juvenile Justice Act Rule 12, ಏನ್ ಹೇಳ್ತದೆ, ಏನ್ ಹೇಳಿದೆ ಅನ್ನೋದನ್ನ ನಾನು ನನ್ನದೊಂದು 3 ಜಜ್ಮೆಂಟ್ಗಳಲ್ಲಿ ಡೀಟೇಲ್ ಆಗಿ ಬರೆದಿದ್ದೇನೆ. ಇನ್ನೊಂದು 15 ದಿವಸ ಕಾದ್ರೆ ಇನ್ನೊಂದು ಜಜ್ಮೆಂಟ್ ಅದ್ರ ಬಗ್ಗೆ ಬಹಳ ಡೀಟೇಲ್ ಆಗಿ ಬರ್ತದೆ. ಅಂಡರ್ ವಾಟ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ದಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಅಂಡ್ ಫ್ರಮ್ ವಾಟ್ ಆಂಗಲ್ ಅಂತ ಅದನ್ನ ನೋಡಿ ಅದಕ್ಕೆ ಇದೆಲ್ಲದರಲ್ಲೂ ಆನ್ಸರ್ ಸಿಗ್ತದೆ. ಎಲ್ಲದಕ್ಕಿಂತಲೂ ಮುಖ್ಯವಾಗಿ ಇದರಲ್ಲಿ ಸ್ಕೂಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇರ್ಲಿ ಇಲ್ಲದೆಯೇ ಇರ್ಲಿ, ನೊಂದವಳೆ ಬಂದು ನನ್ನ ಜನ್ಮ ದಿನಾಂಕ ಇದು ಅಂದಾಗ ನೀವು ನೆಪ ಮಾತ್ರಕ್ಕಾಗಿ ಆದರೂ ಅದನ್ನು ಅಲ್ಲಗೆಳೆದಿಲ್ಲ. ಅಷ್ಟೇ, ಅದೇ ಮೇಜರ್, ಅಷ್ಟು ಸಾಕಾಗ್ತದೆ. ನೆಪ ಮಾತ್ರಕ್ಕಾಗಿ ಆದರೂ ನೀವು ಯಾವಾಗ ಅಲ್ಲಗೆಳೆಯುವುದಿಲ್ಲವೋ, ದಿ ವೆರಿ ಪ್ರೋಸೆಸ್ ಆಫ್ ಪ್ರೂವಿಂಗ್ an allegation is by leading the evidence. Thus, when a witness on oath in a court of law has made a statement regarding the existence of a fact which has not been denied by the other side, Section 3 of the Evidence Act, that has to be construed in favor of the person who gives that statement. You have not denied. ಅವ್ರ ಅಮ್ಮ ಬಂದು ಘಟನೆ ಆಗುವಾಗ ನನ್ನ ಮಗಳಿಗೆ 16 ರಿಂದ 17 ವರ್ಷ ವಯಸ್ಸಾಗಿತ್ತು ಹೇಳಿದಾಳೆ. ನೀವು ಅದನ್ನೂ ಡಿನೇ ಮಾಡಲಿಲ್ಲ. PW12 ಆಕೆಯ ಸಾಕ್ಷ್ಯದಲ್ಲಿಯೂ ಕೂಡ 2 ಕಡೆ ಆಕೆ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಹೀಗೆ ಇದೆ ಅಂತಾನೆ ಹೇಳಿದ್ದಾಳೆ. ಆಕೆಯ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲೂ ನೀವು ಅದನ್ನು ಡಿನೇ ಮಾಡಲಿ. ಇಷ್ಟೆಲ್ಲ ಇದ್ದಾಗ ಹೇಗ್ರಿ? ನನಗೆ ಒಂದು ಪಾಯಿಂಟ್ ಸಿಕ್ಕರೆ ಸಾಕು ಅಲ್ವೇ? ಏಣಿಯಲ್ಲಿ ಒಂದು ಮೆಟ್ಲು ಇದ್ರೆ ಸಾಕು, ಉಳಿದ ಮೆಟ್ಲುಗಳನ್ನು ಹುಡ್ಕೊಂಡು ಹತ್ತುತ್ತೇವೆ. ಇನ್ನು ನೀವು ಎಲ್ಲ ಮೆಟ್ಲುಗಳನ್ನು ಒದಗಿಸಿ ಕೊಟ್ರೆ ಹತ್ತದೇ ಇರ್ಲಿಕ್ಕೆ ಸಾಧ್ಯವೇ? ಮೇಲೆ ಹತ್ತುತ್ತೇವೆ ಮಜಲ್ನ. ಅದೇ ನಾನು ಏಜ್ ರಿಲೇಷನ್ ಅಲ್ಲಿ ಬರ್ಸಿದ್ದೇನೆ ಡೀಟೇಲ್ ಆಗಿ. ಎಸ್, ಆದ್ರೂ ಕೂತ್ಕೊಳ್ಳಿ. ಏನು ಇಷ್ಟೆಲ್ಲ ಹೇಳಿದ್ದೀರಿ, ಸ್ವಲ್ಪ ಈ ಪಾಯಿಂಟ್ ಅಲ್ಲಿ ನೋಡೋಣ. ಪಾಕ್ಸೋ ಅಲ್ಲಿ
The accused has also been charged with offense under section 11(4), that with section 12 of the
Pox Act. Section 11 defines a sexual harassment in which subsection 4 is sexual harassment. Section 11(4) reads as below. 11(4) ನ ಕಾಪಿ ಮಾಡಿ ಕರೆಕ್ಟ್ ಮೆಥಡ್ ಅಲ್ಲಿ ಕಾಪಿ ಮಾಡಬೇಕು. ಹೆಚ್ಚು ಕಡಿಮೆ ಏನಾದ್ರು ಮಾಡಿದ್ರಿ ಅಂದ್ರೆ ಒಂದು ವಾರ ಓಡಾಡಿಸ್ತೇನೆ.
ಇಲ್ಲ ಸರ್.
ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಅದು ಹೇಗೆ ಅಂತ ಒಂದು ಸಿಸ್ಟಮ್ ಇದೆ. ಗೊತ್ತಿಲ್ಲದವರು ನನ್ನ ಚೇಂಬರ್ ನೋಡಿ ಗೊತ್ತಿದೆ ಕೇಳಿ. ನಿಮಗೂ ಹೋದ್ ಸರ್ತಿ ಹೇಳಿದ್ದೇನೆ ನಾನು ಹೇಗೆ ಅಂತ ಎಕ್ಸ್ಟ್ರಾಕ್ಷನ್. ಎಸ್. Accordingly, there ought to be repeatedly or accordingly, the act of the sexual intent should have been a repeated or consistent act of following the victim or watching her or contacting her either directly or through electronic, digital or any other means. The learned counsel, the learned HCGP for the state and the learned amicus curiae for the victim in their argument vehemently submitted that the victim, as PW1 in her evidence has clearly stated that while she was at Bengaluru, the accused was repeatedly telephoning her and stating that she was loving her and teasing her and also troubling. Was repeatedly telephoning her, stating her that he was loving her and also teasing and troubling her. The said statement of the victim has been denied in her cross-examination. Even if the said statement is read and taken on its face value, still the same is not without serious doubts. The first and foremost doubt that creeps in believing the said statement is that though the witness has stated that the accused was calling her over the phone repeatedly, teasing her and troubling her, however, the witness has not even narrated the details of any one of such incidents. Had such an act of accused was repetitive, definitely the victim was expected to remember at least some of them with the details as to the date, time, place, manner, mood, etc. As such, her statement is very bold and vague in alleging that the accused was teasing her and repeatedly telephoning her and also disturbing. Secondly, Sapyara, in the first part of her examination in chief, the witness has stated that while she was at Bengaluru, she received a message to her cell phone as ;, I love you. However, she could not know who the sender was. As such, she ignored that. The very same witness in the later part of her evidence has stated that while she was at Bengaluru, the accused was repeatedly telephoning her and was telling that he was loving her and also teasing. If her second statement that the accused was regularly calling her over the phone and telling that he was loving and also teasing her is taken as true, then it also has to be necessarily taken that PW1, the victim, was aware of the telephone number of the accused and aware as to who the caller was. As such, when she is said to have received message to her cell phone as I love you, she cannot say that she was not aware who the sender of the message was. Thus, the very same statement of the complainant oblique a victim made at two different places don't sail together, and each demolishes the evidentiary value of each creates a doubt in believing the other statement. As such, in the absence of any detail as to when and in what manner, when, where and in what manner the accused has contacted her, either directly or through electronic or digital media, including the phone, it cannot be taken as established that the accused was sexually harassing her in a manner as alleged by PW1. The evidence of PW2 regarding the alleged sexual harassment by the accused is admittedly a hearsay based upon the alleged information said to have been given to her by none else than her daughter, that is PW1. When the very evidence of PW1 regarding the alleged sexual harassment is not believable, the information collected by PW2 from PW1 as a hearsay also carries no weight in proving the alleged guilt against the accused. Lastly and finally, it also cannot be ignored of the fact that the charge alleged against the accused for the offense punishable under section 11(4) read with section 12 of POCSO is as the sexual harassment said to have been committed on charge code reality committed on 27/12/2013 at about 10:30 a.m. The charge does not say that the alleged act of sexual harassment was committed at a different place, that is at Bengaluru, and on a previous date, which is prior to the date 27/12/2013. Thus, the very charge for the offense under section 11(4) read with section 12 of POCSO Act, since it is confined to the alleged incident, if any, said to have taken place on 27/12/2013, and admittedly the prosecution has not considered the same and led any evidence on the point of alleged sexual harassment on the date 27/12/2013, on the said technical ground also, it has to be held that the prosecution has utterly failed to prove the alleged guilt against the accused under section 11(4) read with section 12 of the Prevention POCSO Act. Thus, even though the appellants in both the appeal were able to prove the guilt against the accused punishable under section 307 of Indian Penal Code, however, they have failed to prove the alleged guilt against the accused for the offense punishable under section 354 of Indian Penal Code and under section 11 4, read with section 12 of POCSO Act. Since the trial court, as observed above, did not analyze the evidence placed before it in its proper perspective, on the contrary, though it held the accused guilty of the offence punishable under section 324 IPC, but failed to notice that the evidence placed by the prosecution is sufficient to attract section 307 IPC, the said impugned judgment warrants interference at the hands of this court in the form of modification. Accordingly, we proceed to pass the following order. Criminal appeal number 1786 of 2017 connected with criminal appeal number 491 of 2017. Partly allowed. The judgment of conviction and order on sentence dated so and so, passed by so and so in SC number, in special case number so and so, stands modified to the effect that to the extent that the judgment of conviction holding the accused guilty of for the offence punishable under section 324 of IPC stands modified, and the accused Shri So-and-so Hesru Kula Gotra Nakshatra is found guilty for the offence punishable under section 307 of Indian Penal Code. The rest of the finding of the trial court in acquitting the accused for the offence punishable under sections 354 of IPC, 354, 326 of IPC, and under section 11(4) read with section 12 of POCSO stands confirmed. ಇಲ್ಲಿ ಫಸ್ಟ್ ಮೇಲೆ ಬನ್ನಿ, ಮೇಲೆ ಬಂದು ಪಾರ್ಟ್ಲಿ ಅಲೋಡ್ ರಿಕ್ವೈರ್ಸ್ ಮಾಡಿಫಿಕೇಶನ್ ಅಂತ ಬಂತಲ್ಲ, ಓದಿ ಅದನ್ನ ಮಾಡಿಫಿಕೇಶನ್ ಆದ್ರ ಮೇಲೆ
Criminal appeal number 1786 of 2017 connected with criminal appeal 491 of 2017 are partly allowed. The interim judgment of conviction dated will stands modified to the extent that the judgment of conviction holding the accused
to the extent that the order of acquittal of the accused for the offence punishable under section 307 of Indian Penal Code stands set aside. ಮುಂದಿನ
stands set aside and the accused is found guilty for the offence punishable under section 307 of IPC. The rest of the finding of the trial court
ಎಲ್ಲೋ ಸೇರಿಸಿದ್ರೆ ನೀವೆಲ್ಲೋ ಸೇರಿಸಿದ್ದೀರಿ.
To the extent that order of acquittal of the accused for the
ಫಸ್ಟ್ 307 ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿಫಿಕೇಶನ್ ಬರಬೇಕು, 307 ಅಲ್ಲಿ ಅಕ್ವಿಟಲ್ ಸೆಟ್ ಅಸೈಡ್ ಆಗಬೇಕು, ಆಮೇಲೆ 324 ಮಾಡಿಫೈ ಆಗಿ ಅದು 307 ಕನ್ವಿಕ್ಷನ್ ಅನ್ನೋದಾಗಬೇಕು, ಆಮೇಲೆ ಉಳಿದಿರೋದು ಎಲ್ಲದರದ್ದು ಅಕ್ವಿಟಲ್ ಕನ್ಫರ್ಮೇಶನ್ ಆಮೇಲೆ ಬರ್ತದೆ. ಇದೇ ಆರ್ಡರ್ ಅಲ್ಲಿ ಬರಬೇಕು. ಆರ್ಡರ್ ಸ್ವಲ್ಪನೂ ಹೆಚ್ಚು ಕಡಿಮೆ ಆಗ್ಬಾರ್ದು.
The rest of the finding of the trial court in issuing the accused convicted under section 354 and 326 of IPC and under section 11(4) read with section
ಅದನ್ನ ನೋಡಿ ರಿಅರೇಂಜ್ ಮಾಡಿ ಹಾಕಿ. ಈಗ ಏನ್ ಹೇಳಿದೆ ಇದೇ ಆರ್ಡರ್ ಅಲ್ಲಿ ಬರ್ಬೇಕು. ಆರ್ಡರ್ ಹೆಚ್ಚು ಕಡಿಮೆ ಮಾಡಬೇಡಿ. 326 ಇದೆ ನಾನು ಅದರಲ್ಲಿ ಏನು ಹೇಳಿದ್ದೆ ಅದಕ್ಕೆ ಮರ್ಜೆಂಟ್ ಮಾಡಿದ ಕನ್ವಿಕ್ಷನ್ ಹೇಳಿದ್ರೆ ಇಲ್ಲಿ ನೋ ಸಪರೇಟ್ ಸೆಂಟೆನ್ಸ್ ಇಸ್ ಗಿವನ್. ಕನ್ವಿಕ್ಷನ್ ಹೇಳಿದ್ರೆ ನಿಮಗೆ ಕನ್ವಿಕ್ಷನ್ ಇದು ಒಂದು ಮಿನಿಮಮ್ ಒಂದು ಲೆಂತಿ ಪ್ರೀವಿಯಸ್ ಇಂಜುರಿ ಅನ್ನೋದು PW18 ಪ್ರೀವಿಯಸ್ ಇಂಜುರಿ ಅಂತ ಹಾಕುತ್ತೆ, PW11 ಸಿಂಪಲ್ ಇಂಜುರಿ ಅಂತ ಹಾಕುತ್ತಲ್ಲ ಎಕ್ಸ್ಪ್ಲನೇಷನ್. Acquittal for section so and so ಅಂತ ತಗೊಳ್ತೀರಲ್ಲ, the judgment of acquittal given by the trial court for the offence punishable under section 354 of IPC, 326 ತೆಗಿರಿ, 354 of IPC and under POCSO Act so and so stands confirmed. Yes, since section 326 of IPC stands in the circumstance of the case stands merged into section 307 IPC. No finding on the said offence is explicitly given. Amen to hear on sentence. Next one. Yes. What is it?
appeal complainant prayer ಬರೀ 307 ಮಾತ್ರ ಇತ್ತು, partly allowed ಅಂತ.
ನಿಮ್ಮದು ಬರೀ 307 ಗ
ಹೌದು
ತೆಗೀರಿ ಅವ್ರಿಗೆ ಪ್ರೇಯರು. ಇನ್ನೊಂದ್ರದ್ದು ಪ್ರೇಯರ್ ತೆಗೀರಿ, ಇಬ್ಬರದ್ದು ಪ್ರೇಯರ್. ಇದು 1786 ಅದೇ ಕಂಪ್ಲೇಂಟ್ಸ್ ತಗೊಂಡು Criminal Appeal 1786 of 2017 allowed ಅಂತ ಮಾಡಿ ಪಾರ್ಟ್ಲಿ ಏನಾದ್ರು ತೆಗೀರಿ. Criminal Appeal for 491 of 2017 is partly allowed ಅಂತ ಮಾಡಿ. ಇದರಲ್ಲಿ ಇದೊಂದು ಸೇರಿಸಲಿಲ್ಲ, was of unsound mind. That ನೀರು ಹೌದು Yes, please.
Facts and circumstances of the case, considering the old case of the old case. Lenient. Was 25 to 26 years. Who the incident is of the year now 2013. He may be around 35 to 38 years. Keeping the age also.
So still able to. Yes.
She being a minor girl, my lords, who has lost precious years of her life, with serious injuries on her, no lenient view should be taken.
SCG.
For the minor girl, maximum punishment may be awarded.
Sahib. ಎಲ್ಲ ಮಾಡಿ ಅವರೇ ಡಿಲೇ ಮಾಡಿ ಇದು ಒಂದು ರೇಪ್ in the court of first instance or in the appeal. As a general practice, the accused cannot seek for a liberal approach in ordering the sentence. However, considering the mitigating factor in the matter, including the alleged dependency upon the accused and his alleged family holding, we are of the view that though the maximum sentence which can be ordered is imprisonment for life. However, since the very same section also empowers us to order such punishment as herein before in the said section mentioned, we are proceeding to ಈಗ ನಮ್ಗೆ 10 years ಕೊಡ್ಬೋದಾ ನಾವು? ಹೌದು, since up to 10 years ಅಂತ ಇದೆ. ಅರ್ಥ ಇರೋದ್ರಿಂದ ಲೈಫ್ ಕೊಡಬೇಕು. ಇದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಪಾರ್ಟ್ ನಲ್ಲಿ if hurt is caused to any person by such act, the offender shall be liable either to imprisonment for life or such punishment as is herein before mentioned. ಅಂತ ಇಲ್ಲಿ ಹರ್ಟ್ ಇದೆ. ಅಪ್ ಟು 10 years ಅಂತ ಅಪ್ ಟು 10 years ಅಂತ ನಾವು ಕಡಿಮೆ ಕೊಡ್ತೇವೆ. ಹರ್ಟ್ ಇಲ್ಲದೆ ಹೋದ್ರು ನಾವು ಕಡಿಮೆ ಕೊಡ್ತೇವೆ. ಇದ್ರಲ್ಲಿ ಹರ್ಟ್ ಇದ್ರು ನಾವು 10 years ಕಡಿಮೆ ಮಾಡೋದ್ರ ಬದಲು ಹರ್ಟ್ ಇರೋದ್ರಿಂದ 10 years ಅಂತ ಕನ್ಫೈನ್ ಮಾಡಿಸ್ತೇವೆ. ಅವ್ರ ಮೇಲ್ ಹೋದಾಗ 6 years ಇಳಿಸ್ಕೊಂಡ್ಬರ್ತಾರೆ. ಹರ್ಟ್ ಇದ್ರು ನಾವು ಲೆಸ್ ದನ್ 10 years. ಹರ್ಟ್ ಇಲ್ಲದೆ ಹೋದಾಗ ಹರ್ಟ್ ಇದ್ದಾಗ ಏನ್ ಕೊಟ್ಟಿದ್ದೇವೆ ಅದಕ್ಕಿಂತ ಕಡಿಮೆ ಕೊಡಬೇಕಾಗುತ್ತೆ. Accordingly, we proceed to pass the following order. The accused so and so. ಅದನ್ನೆಲ್ಲ ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ ಹಾಕಿ ಸೆಂಟೆನ್ಸ್ ಟು ಅಂಡರ್ಗೋ. Sentence to undergo simple imprisonment of 10 years. And to pay a fine of rupees. Fine of rupees 20,000 rupees. In default of payment of fine to undergo an additional simple imprisonment of 6 months. 6 months. Out of the fine amount paid by the accused, if any, a sum of rupees 18,000 be paid to PW1, the victim, as compensation under section 357 now. CRPC. Victim compensation 357A ಏನಾದ್ರು ಹೇಳ್ಬೇಕಾ? ಅದೆಲ್ಲ ಆಗಿರಲ್ಲ. 1,180 ರೂಪಾಯಿ ಕಟ್ಟಿದ್ದಾರೆ. The order and sentence passed by the special court stands modified on the lines mentioned above. The rest of the observation of the session special court in the impugn judgment regarding disposal of the property at MO 1 to 7 stands confirmed. Accused shall surrender before the special court within 45 days. ಅದಕ್ಕೆ ಮುಂಚೆ section 428 set off ಹಾಕಿ 45 days surrender, free copy, amicus curiae assistance appreciation, an honorarium of not less than a sum of rupees 6,000 to each of the amicus curiae, payable by the registrar. Transmit trial court record. Yes. Stands modified ಅಂದ್ರೆ ಅವಾಗ ಇದು ಆಗ್ತದೆ, ಇದೇ ಬರ್ತದೆ. ಆದ್ರೂ ಟು ಗಿವ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಇವೆಲ್ಲ ಡೌಟ್ಗಳು ಬರೋದೇ ಇಲ್ಲ. ಆ ಸೆಂಟೆನ್ಸ್ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಮಾಡಿಫೈಡ್ ವಿತ್ ದಿಸ್ ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ರು 10,000 ರೂಪಾಯಿ ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ರಿಮೈನಿಂಗ್ 30,000 ರೂಪಾಯಿ, ರಿಮೈನಿಂಗ್ 10,000 ರೂಪಾಯಿ ಕಟ್ಟು ಅನ್ನೋದಷ್ಟೇ ಬರ್ತದೆ. The fine amount deposited, if any, by the accused already in the matter be adjusted, be given set off in the present fine amount order today. Yes. ಒಂದೇ ಕಲ್ಲು 2 ಟನ್ ಇನ್ನೊಂದು ಯಾವ್ದಿದೆ ಪಾಸ್
Bill number 4, Harish Bhandari T, Sandesh Shetty for connected matter
from both sides present. Since the court time is over, the matter could not be proceeded today. List the matter on. ನಿಮ್ಮನ್ನ ಕೇಳದೇ ಇಲ್ಲ, ನಿಮ್ಮನ್ನ ಕೇಳಿದ್ರೆ ಯಾವ ನೀವು ಬಹಳ ಲಾಂಗ್ ಡೇಟೇ ಹೇಳ್ತೀರಿ. Henceforth, I don't ask the prosecution as to when do you want. ನಾಳೆನೇ ಅಂದ್ರೆ ಅವಾಗ ನಿಮ್ಮನ್ನ ಕೇಳ್ಬಹುದು, ನೀವು ನಾಳೆ ಅಂತೀರಿ ಅವ್ರು ನಾಡಿದ್ದು ಅಂತಾರೆ ಅಂತ. ಅವ್ರು ಮಂಡೇ ಅಂದ್ರೆ ನೀವು ಟ್ಯೂಸ್ಡೇ ಅಂತ ಹೇಳಿದ್ರೆ ಅವಾಗ ಕೇಳಲ್ಲ. ಇವತ್ತು ಯಾವ ವಾರ?
ಇವತ್ತು ಬುಧವಾರ, ಬುಧವಾರ. ನಾಳೆ 2 ಪಾಠ.
ಎಷ್ಟು ಇವತ್ತು?
ಇವತ್ತು 22.
22 ಅಂದ್ರೆ 27 ಏನಿದೆ ನೋಡಿ.
27 ಒಂದು ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಇದೆ ಅಷ್ಟೇ. 3 ಮ್ಯಾಟರ್ ಇದೆ ಡೇಟ್ ಗಿವನ್. ಶುಕ್ರವಾರ ಒಂದಿದೆ ಪಾರ್ಟ್ ಮ್ಯಾಟರ್.
ಶುಕ್ರವಾರ ಆಗ್ಬೋದಾ ಸೋಮವಾರ ಆಗ್ಬೋದಾ ಭಂಡಾರಿ ಅವರಿಗೆ? ನಿಮಗ್ ಸೋಮವಾರ ಏನಾರ ಅನುಕೂಲತೆ ಇದೆ? 2 ಮ್ಯಾಟರ್.
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಫ್ ಕಾಂಪೌಂಡ್
ದಿವ್ಸಕ್ಕೆ ಒಂದೇ ಅಂತ ಹೋಗ್ಬಾರ್ದ್ರಿ. ಮ್ಯಾಟರ್ ಆನ್ 28/11. Matter 28/11 on the top of the list. 28 ಟಾಪ್ ಇರ್ತದೆ, ಬೆಳಗ್ಗೆನೆ ಬರುತ್ತೆ.
serial number 5, STP, yes Vinayaka.
Counsels from both sides present. ಇದರಲ್ಲೂ since the court time is over, the matter could not be reached. List the matter. Amicus curiae.
Friday. Afternoon, I am ready.
ನಾಳೆ ಯಾವ್ದು ಇದೆ?
ನಾನು 2 ಪಾಠ ಇದೆ. ಒಂದು
ಶುಕ್ರವಾರ. ಶುಕ್ರವಾರ. Is the matter on 24, 11. ಅದ್ರಲ್ಲಿ ಒಂದು ಟಾಪಿಕ್ ಹಾಕ್ಸಿ ಇನ್ನೊಂದು ನೆಕ್ಸ್ಟ್ ಉಳಿದಿದ್ದೆಲ್ಲ ನಾಟ್ ರೀಚ್ ಮಾಡಿ. ಯಾವುದು 6 and 6 ಮಾತ್ರ 6, 8, 9, 10 ಅದನ್ನು 2 days ಅಲ್ಲಿ ಸ್ಪ್ರೆಡ್ ಮಾಡಿ ರಿಪೀಟ್ ಕೊಡಿ. ಒಂದೇ ದಿವಸಕ್ಕೆ 4 ಮಾಡ್ಕೊಳ್ಳಿ. 2 ಮ್ಯಾಚ್ ಮಾತ್ರ ಮತ್ತೆ ವೀಕ್ಲಿ ಸೀರಿಯಲ್ 6 ಅಲ್ಲಿ ಯಾರಿದ್ದೀರಿ? HCGP ನೀವಿದ್ದೀರಿ.
ಅಮಿಕಸ್ ಕ್ಯೂರಿ ರಿಲೀವ್ ಆಗಿ ಪವನ್ HK ಅವರು
ಅಮಿಕಸ್ ಕ್ಯೂರಿ
ಅಪಾಯಿಂಟ್ ಆಗಿತ್ತು ಮೇಲಾಟ ಇದ್ರಲ್ಲಿ ಅವ್ರು ರಿಲೀವ್ ಮಾಡಿ ಪವನ್ HK ಅವ್ರು ಮತ್ತೆ ವಾಪಸ್ ರೀಇನ್ಸ್ಟೇಟ್
ವಾಪಸ್ ಬಂದಾರೆ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ವಿತೌಟ್ ಟೇಕಿಂಗ್ ಎನಿ ಟೈಮ್ ಐ ಗೋ ಅಂತ. ನಾಳೆ ಯಾರಿದೆಯಾ?
ನಾಳೆ ಟೋಟಲ್ 4 ಇದೆ ನನ್ನ ಡೇಟ್ಗಳನ್ನು, ಅದರಲ್ಲಿ 2 ಪಾಠ ಇದೆ. ನಾಳೆನೇ ಆಗ್ತದೆ.
ಟುಮಾರೋ ನಾಟ್ ರೀಚ್ ಅಂತ ಮಾಡಿ. ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪಲೆಂಟ್ ಅಲೋನ್ present. Since the court time is over, matter could not be taken up today. This matter on 23/11. ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಅಲ್ಲಿ ಯಾರಿದ್ದೀರಿ? ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಇಬ್ರು ಇದ್ದೀರಿ. ಗೋಪಾಲ್ ಕೃಷ್ಣಮೂರ್ತಿ ಶ್ರೀನಿವಾಸ್. ನಿಮ್ಗೊಂದು ಕ್ಲಿಯರ್ ಡೇಟೇ ಕೊಡುವ. ಎವ್ರಿ ಡೇ ಬೋತ್ ಆಫ್ ಯು ಆರ್ ಕಮಿಂಗ್ ಅಂಡ್ ವೈಟಿಂಗ್. Tuesday 28, Tuesday second top of the list. ಅವತ್ತಿನ ದಿವಸ ಬರೀ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇರ್ತದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 9, learned counsels from both sides present. Since the court time is over, the matter could not be taken up today. Killing the uncle alwa, Rangaswamy murder, land dispute, circumstantial evidence. Since the court time is over, learned counsel from both sides present. Since the court time is over, matter could not be proceeded today. List this matter. ಈಗ ನಾವು ಮಂಗಳೂರಿಗೆ ಹಾಕೊಂಡಿರೋದು ಯಾವ್ದು ಹೇಳಿ? ಹರೀಶ್ ಬಂಡಾರಿ. Yes. List the matter. 28/11. ಮಂಡೇ ಓದಿದೆ.
ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್
ನಿಮಗೆ ಮಂಡೇ ಆದೀತಾ ಟ್ಯೂಸ್ಡೇ ಆದೀತಾ? ಇಬ್ಬರಿಗೂ ಟ್ಯೂಸ್ಡೇ ಆದ್ರೆ ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್, ಮಂಡೇ ಆದ್ರೆ ಫಸ್ಟ್ ಮ್ಯಾಟರ್. ಟ್ಯೂಸ್ಡೇ 28/11/2023 as the second top matter.
ಫೈನಲ್ ಹಿಯರಿಂಗ್
9 and 10 ಇದೆ. 9 ನಲ್ಲಿ ಯಾರಿದ್ದೀರಿ ಅಂದ್ರಿ?
SPP Anmaya HC
28, 20.
correspondent
9 ಈಗ
9 ಆಯ್ತು. ಡೇಟ್ ಕೊಟ್ಟಿದ್ದು
ಸೀರಿಯಲ್ 9, ಸೀರಿಯಲ್ 8 2058.
Serial number 8 SPP Anmaya HC for respondent.
You are there. Tomorrow ನಮ್ಗೆ ಇನ್ನೊಂದಿದೆ. ಇನ್ನು 2 ಪಾರ್ಟ್ 2 ಮ್ಯಾಟರ್ ಇದೆ ನಾಳೆ. ಬೇಡ. Learned additional SPP for the appellant is physically present. Learned counsels for the respondents not present. Court time is also over. List the matter on 27. 27. What? ಗುಲ್ಬರ್ಗ ಇದೆ. 24/11. Serial number 10 ಯಾರಿದ್ದೀರಿ?
SPP Venkatesh for
ನಾವೇ
respondent.
ಇದ್ದೀವಿ. Yes. Learned additional SPP for the appellant present. Learned counsel for respondent not present. Not present. Could order sheet could. It is made clear to the respondent that in case if the learned counsel for the respondent fails to appear on the next date of hearing and proceeds in the matter, the court may proceed to pass appropriate order. 711 ಮಾಡಿದ್ದೀವಿ. ಓ ತಡೀರಿ, ಇದರಲ್ಲಿ ಎಲ್ಲ ಮಂತ್ರಗಳು ಮುಂಚೆ ಹೇಳಿದ್ದೇವೆ. Learned additional SPP for the appellant is present, learned counsel for the respondent not present. On 7/11/2023, due to the absence of the learned counsel for the respondent, matter could not be proceeded. On that day, it was made clear that if the learned counsel for the respondent fails to appear on the next date of hearing and address his argument, the court would proceed to pass appropriate order, including appointing an amicus curiae for the respondent. Thereafter, the matter came on several dates, on few dates of hearing. On 21/11/2023, once again, though the learned SCGP for the appellant was present, learned counsel for the respondent remained not present. Accordingly, the matter was taken up today. Even today also, the learned counsel for the respondent not present. Under the above circumstance, and also keeping in mind that the present appeal is of the year 2018, as such one of the old appeals of this nature pending before this roadster, we are proceeding to appoint an amicus curiae for the respondent. Accordingly, learned counsel ಶ್ರೀಮತಿ ಕೇಮ್ ಯಾರು ಮಾಡ್ತೀರ್ರಿ? ನಿಮ್ಮದ್ರಲ್ಲಿ ನೀವು ಮಾಡಿ. 376 ಇದೆ. Learned counsel ಶ್ರೀಮತಿ KM Archana, who is physically present, is appointed as amicus curiae for the respondent. ಮುಂದಿಂದೆಲ್ಲ ಹಾಕಿ ಫಾರ್ಮೆಟ್. Wish the matter on 29/11. ಅದರಲ್ಲಿ previous counsel stands relieved ಅನ್ನೋದು ಬರಬೇಕು.